Hello. Excellent. Your turn.
Good morning. I'm Jeff Ashby, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in this room, I believe, and they've been made available electronically as well. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today.
Commissioner, before you move adoption of the agenda, I would note there is one amendment to it. There is one case on the hearing agenda that has been tabled. So when there's a motion to adopt the agenda, it should be the amendment to adopt the agenda as amended and the consent agenda.
I will entertain that motion. So moved.
So it's been moved and seconded to adopt today's amended agenda and consent agenda. And just as a reminder for folks, if we have people participating remotely, which we do, I am required by our remote participation policy to ensure that every vote of the commission is able to be seen both visually and heard. So I'll be asking commissioners for every single vote, commissioner by commissioner, and making sure they show and say their vote. So if you're in agreement to adopt the amended agenda and the consent agenda, you'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Thank you.
All right, I have a procedural question about the minutes for the June 23 meeting. I wasn't present, and I know we have a quorum to start the meeting. We have a quorum to vote on the minutes.
We do.
For 23, if I abstain, because I am going to abstain. I'll entertain a motion to accept the minutes of the June 2023. Second.
So it's been moved and seconded to adopt the minutes of the June 2023 meeting. Any discussion? Forgot to ask that. Seeing none, if you're in agreement, you will vote yes. Commissioner Ashby?
Abstain.
Mr. David?
Yes.
Commissioner O'Brien? Yes. Thank you.
Amy, the director's report.
Yes. Let's see, you have from me a personnel report. And there are nothing particularly to report there other than the meeting for you're over there. Oh, wait, you're far away now.
Like 3 minutes late.
Yeah, well,
Go sit in the corner. I love you all. Good morning. Yes.
good morning. For compliance, there were no successful conciliations since the last meeting. There were 2 unsuccessful conciliations. There are 2 conciliations pending. There are no conciliation agreements to review. For investigation, you have a case activity summary from me that looks like this little chart. And it shows that in June, we received 32 new complaints. I administratively dismissed 10 cases. And there were 14 predetermination settlements with benefits of over $670,000 to complainants. This is a quarterly meeting, so you have some quarterly reports. You have a finance report that folks from DAPS prepared for us. And it's got all sorts of interesting tabs and sub-reports. It's an Excel spreadsheet, so I encourage you to feel free to look through that and let me know or Kit know if you have any questions. You also have a quarterly training and education report showing that commission staff participated in or attended 20 educational events in the quarter that just ended. And we don't have a report on pending inventory because since these reports are confidential from the database, I decided I would stop giving them to you. But if you did, it would show that there are 614 complaints pending currently. For new business, not a lot. The legislative session finally ended. It was pretty long. Good news, great news is that when the budget was finally signed, we did get 2 positions in the budget. I can't remember if I talked about this the last time. Did I? I don't remember, but it's great news. Huge, fantastic news for us. Getting positions is a big deal. One is an investigator position and one is a business manager position, because we desperately need someone to work on our accounts receivable, our bills and our billings. So this will take pressure off of one of our front office staff who has been doing work that she's had to learn how to do and really struggle to figure out. She's been a champ, but this will take so much pressure off of a lot of people. So that's huge for us. The only other new thing on the legislature is that a bill to expand the definition, no, actually it doesn't expand the definition, a bill to apply the Maine Human Rights Act to people who are receiving services from a public entity. If you remember, this is about prisons and jails. The parts of correctional facilities that are not open to the public. There was a bill, something that we have looked at in the past and proposed over the past 2 sessions. Someone else has submitted it and it did pass. And it was enacted and it was actually funded because the Department of Corrections asked for some positions and the Attorney General's office asked for some positions, saying that it would increase their workload both. And it actually got funded off of the legislature's special appropriations table, which is honestly kind of surprising. And I believe it was passed and enacted just before the legislature.
It's the same day they decide that.
So the governor gets 10 days to either sign it or veto it or let it go into effect without her signature. But because the legislature adjourned, we believe that it will be there. It's not enacted. She has time when the legislature comes back for its next special session.
Yeah, what I think happens is that by the 4th day of the next session, because it's the same legislature, that she can veto it by the 4th day. But it's a little mysterious.
Yeah.
But I'm pretty sure that's the way it works.
We're fairly not sure, but there's a pretty decent chance it'll get to it.
Can you explain what you mean? What's like not public?
So there are parts of prison and jail or correctional facilities that are open to the public, like lawyers come in to see their clients, or people get to come visit their loved ones or their family members who are in correctional facilities. Those parts that are open to the public fall under our public accommodation statute, right? So they can't discriminate against visitors or people getting services in those open to the public parts. But the other parts generally are not open to the public. And right now, under the interpretation of the Maine Human Rights Act that's been in effect for 15 or so years, the only part of the Maine Human Rights Act, the only protection that applies is disability. So people who are in correctional facilities, who are in jail and prison, if they are discriminated against based on sex, race, national origin, the current interpretation of the Maine Human Rights Act is that we don't have jurisdiction to get to investigate their complaint. So if we get them, and we do, we have to dismiss them for lack of jurisdiction. 3 sessions ago, we included as part of a bill that the commission introduced to address lots of inconsistencies in the statute. An omnibus bill. We included that piece as one of the initiatives. And I believe that time, the first time, it passed through committee and it passed the state Senate and the House, and the governor kicked it back and it went back and forth, I think 3 or 4 times before finally dying on her desk. In a situation much like this, I believe, right at the end of the session.
When we proposed it,
Yeah.
she made us strip it out so that we could get the rest of it passed.
The only way thank you for pointing. The only way we could get the rest of our changes done was to take it out of our bill.
Your thing was the second time.
Okay, so then the second time, it wasn't us who proposed it, it was the legislator. And that time, she kicked it back from the governor's office down to the legislature, back to judiciary, back up and back a few times. And then it died on the appropriations table because corrections or AG's office put a fiscal note on it saying, including those protections would increase the number of lawsuits and create more work for them. We did not attach a fiscal note to it because even though it would be more work for us, we think it's the right thing to do. And so this was the third time that it was proposed again by a legislator, by the Speaker of the House. And it got farther than it's ever gotten. It got committee through the House, through the Senate, on the special appropriations table, because that's where things that cost money go. And along the way on the appropriations table, it was amended several times. The fiscal note was amended several times, including right before it was enacted again and went to the governor, which is where it is now. Does that make things any clearer?
Yeah, yes. I didn't understand.
Yeah,
What part of correctional facility is not.
the parts that are open to the public.
Okay.
So we'll see. Actually, you will see. I will not. So that's all the new business that I have. Yep. Yes.
On the monthly activity in June.
Yep.
And it struck me that I hadn't seen that number here. It's 671,000 floating around. Is that just those cases, or is that year to date? Or
That is the 14 cases, 2 settlements, that's through our mediation program. And 12 cases that settled without our mediation program being involved. That is the money that was included in those 14 cases that went to complaints.
it's substantial.
Sometimes it is, sometimes it's not.
I wonder if that line needs how do you see that it's 14 in that column? I mean, does that need a label, the 671, or maybe not, I guess.
We purposely only report some predetermination settlements in the aggregate to commissioners because for most, but number one, many respondents are very, very anxious about commissioners seeing a settlement with their name on it for fear that commissioners will assume wrongdoing when sometimes respondents settle cases, and so do complainants for a number of reasons.
Yeah, no, I'm not saying that it ought to be keyed to specific cases, but just how in that column is you say it's 14?
So if you see the line for settlement,
2.
yep, and the next line, withdrawals with benefits.
So it's those 2 together.
Yes.
14.
Yep.
And those 14 are the 671,000.
Yes, this is the same report I give you every month.
Yeah, okay. Well, all right. Okay, thank you.
Okay. Any other?
Yes,
Yeah.
I think this is as good a time to do it as any, in that there's really no good time to do it because I don't want to do it. But I think it's appropriate that we acknowledge that Amy's leaving us.
Done.
And when I said I want to do it, I mean, I don't want to admit it. It's not that I don't want to do it. I couldn't be happier to say a few nice things. But I can't give you the justice that you deserve in any comments that we make here today, unless we extend the meeting significantly. We don't have any gold watches. I was going to bring you a bag of potatoes from Northern Maine, but I didn't come from Northern Maine today. So I just want to say, and I don't want to speak for my fellow commissioners because I'm sure they have something to say as well. And, but I'll say personally, having been with you the longest among us, that it's been a true pleasure to work with you. That we have been very fortunate to have you in your position for as long as we have, for the years of service that you've given us. Your sort of outward facing, public facing work that you've done is widely known, and you're so well respected and admired. You handle our work so sort of ably. Behind the scenes, we hear good news about what happened with the legislature, and we learn that our budget is good, and we commissioners are sort of kept in line by the great work that you do as well. And so both what the world sees and what we see. I guess I can't say enough about how thankful I am for the work that you've done. I wish you all the best in your future endeavors. You're leaving us in good hands and in a good position, a great position, a better position than we've really ever been in, sort of financially, with respect to our personnel. But you're leaving us, we'll be missing you significantly. And so I wish that we could do and say more. I would love to attend a nice steak dinner. We should have thought that one through. If there is a steak dinner, please invite me. But in any event, please go with our best wishes in what you're about to do next.
Thank you very much.
I'll, as the next senior person, it's been a wonderful experience to work with you, Amy, from the very first time that I called you on the phone and you're shepherding me through the confirmation process. You are competent and knowledgeable in the law. Your public facing running of these meetings is gentle but fair and firm. I've never had this slighted feeling that you weren't treating every case with the respect that it deserves. I also think it's unfortunate that we come together so quickly and there's not too much interaction or no interaction between us, so that we fumbled the ball in terms of planning that steak dinner, which ought to be a celebration of a wonderful tenure. And we're going to miss you.
For deals made, there's a reason there's no steak dinner.
That's surprising me.
Thank you so much.
And I'm next. And he was gonna bring the potatoes, and I had two bags of Foley's donuts, which are really good. And Mark said this morning, do you want to, you gotta bring those. I looked in the bag. Guess what? I said, you ate them. I said, no, I can't do that and split it up.
Two for me.
And so I just want to say, ditto to everything. And it has been a pleasure. I mean, it was so long that we were on the screen, and then it was so nice to come in and meet you. And any question I've ever had, you've been very clear about and I've had many. You've been very clear. You've helped me in so many ways, and I know this has been many times a tough job, and you've done it with grace and fairness and empathy and compassion, and I really appreciate those qualities. Good luck, and been very nice dealing with you. Thank you very much. That's really kind.
I don't think Tom Douglas should get in charge.
Speaking as the junior member. I'm just so grateful to have had the opportunity to work with you and serve with you over the last couple of decades, really.
I've been bossing him around for a very long time.
Amy's been bossing me around for a really long time. I've enjoyed every minute. But I mean, it's hard to say anything that hasn't already been said. What I will say is that as somebody who has appeared in front of this body as a litigant and now serves on the commission, it has always been my impression that you run it with the highest sense of integrity and competence. And I think you've just really done an amazing job. And I myself personally am very sorry to see it. Wish you all the best in whatever it is you're going to do. And really hope you will stay in touch.
Thank you. Thank you all. I did not honestly see that coming. I assume that's Barbara's doing. Barbara, she won't look at me, which means it is. Thank you all very much. I really, it's honest. It has been, and I was going to say this after the meeting, but it's truly been an honor to do this work. It's not been easy, but it's been because of the people that I work with and because commissioners have been here. That part has been a tremendous pleasure, and the work itself never fails to be interesting for sure. But makes you feel like you're doing something that matters, and I'm grateful to have been able to do that. So thank you all so much. Oh boy, okay, so let's do some cases.
Want to hear some cases?
Yeah.
So those of you here in the room and online, thank you for indulging us a bit. But we'll move on. Hold on one second. All right. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order of the accepted agenda. And as I call each case, the party who has submitted a written argument will be called to the podium or we'll identify you on Zoom to provide the most relevant arguments to the case. Time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I'll ask that you introduce yourself as you come to the podium. Thank you.
And before the first case, I would just remind folks that the Maine Human Rights Act requires our agency to keep the identities of third parties confidential. So that is why in our reports, we give anyone who's not a party to the case a pseudonym or a way to refer to them that doesn't involve their name. So we'd ask that you utilize what's in the report and not use the names of third parties. And I have a nifty new timer that will show people the time and go off when your time is up. So thank you, Kit.
All right, the very first case we have today is E21-0233ABC. It is Lewis Willett versus the University of Maine system, Susan Robinson and Kim Tran. I'm going to recuse myself from our first case today, so we'll sit somewhere else.
So
Sorry, what one is it?
It is the Willett versus the University of Maine et al. It's E21-0233 ABC.
I see Lewis, and I'm probably going to mispronounce your name. I'm sure the other commissioners said it properly. Lewis Willett. So I don't know if you can see my little timer here. I will hold it up. Assuming I can. Nope, my camera's not on. So I'll just have to tell you that you have 10 minutes and go do it the old-fashioned way. So you can unmute yourself and you have 10 minutes.
Certainly, thank you. I tried to be as succinct as possible in my response to Investigator Bush's his summary, and that's where I put in the clarifying details of it on with the complaint. Yes, I can understand the prima facie, but there's just too many coincidences throughout the entire timeline for there not having been something deeper there. Do I believe that they intentionally did it out of malice? Not necessarily. But the entire situation certainly was mishandled, leading me to feel discriminated against. And to the best of my knowledge, representation for the other parties didn't enter comment. And I wanted to give them a chance to rebut any of the documentation I provided in my email response. So if I can reserve the rest of my time and allow,
Yep, you can.
certainly.
We'll have about just over 8 minutes when we come back. But before we let you go, let's see if commissioners have any questions for you. Commissioner questions for Mr. Willett? Mr. David?
Mr. Willett, the report indicates that there was a PIP plan put into effect. Did you object to that? Did you sign that?
I was told I needed to sign it whether or not I agreed with it. And I made it explicitly clear throughout the entire process from February 25th of 21 all the way through that I did not agree with all of the items in the performance improvement plan.
There also was reference to an independent investigator's report that found no discrimination. Did you object to that?
I did object to those findings, and it was after the fact that said independent investigator is actually on retainer and works for the law firm that is representing the university system in this proceedings.
Thank you.
Any other commissioner questions for Mr. Ouellette at this time? Seeing none, we'll come back to you after we hear from the University of Maine system. So is Ms. Huey, is that you? Yeah. Want to unmute yourself? There you go.
I'm trying.
Okay.
It's only been 2 years. I'm still learning.
Yeah, we all are. Go ahead.
I'm Melissa Huey for the respondents University of Maine system, Susan Robinson and Kim Tran. There actually isn't a lot that I feel the need to add to the investigator's report. I think it was clear. I think the information that the respondent submitted to the commission is information that was available to and considered by the investigator. So I don't think that that adds anything. Basically, what we have here is an employee who did have a disability. There's no doubt that, and I don't think there's any dispute that the university provided him with the accommodations that his medical provider recommended, and actually more than that. And separately, and we contend, unrelatedly, he had performance issues, including an inability or a refusal to finish tasks in a timely manner, and also being late for work frequently because of taking his daughter to daycare. These are not issues that were connected to the disability. They are reasonable issues. And as is referred to in the investigator's report, and one of the commissioners also referred to, the university tried to work with him, put him on performance improvement plans. And I will say, I think that the first performance improvement plan he did refuse to sign. But the issue was to try to improve his performance. He was not able to improve his performance, but they kept working with him. And when performance issues arose, there were some disciplinary letters put into his file. But basically, as the investigator found here, there's really no connection between these performance issues, which the university has an absolute right to address, and the disability. So I think that the investigator's recommended finding of no reasonable grounds is warranted, and I encourage the commission to accept it.
Thank you. Any commissioner questions for respondent at this time? Seeing none, you'll have about 7.5 minutes when we come back. Mr. Lett, you have, I might have written this down wrong, but it seems like you have 8 minutes.
Certainly. So as I outlined in my response, the alleged performance issues were the difference between, as the university has it stated, a tier 3, which is what my job title was, IT specialist, career level 3, that people, employees in those roles have near autonomy. That yes, those roles can have tasks delegated to them, but in the standard course of business in a day, those roles that are designated as tier career level 3 are allowed to manage their time. And one of the initial performance deficiencies that was brought against me was checking the battery levels of door locks over the winter break from middle of December to the middle of January. And as I stated to Ms. Robinson at that time, though that task was better done closer to, just in case any of the doors, for whatever reason, there would be occasionally an error with the door where even if it had a fresh battery, it wouldn't work. So making sure that those were recently visited as the students were coming back to campus was my rationale for waiting until after the new year to address that work task, as opposed to doing it right after the students left in December. As far as the tardiness goes, I outlined in the middle section that of the 60 tardies that Ms. Robinson had marked down, 34 of them were within a 5-minute window of 8 a.m. And as I cited in my response of Keller v. TD Bank, TD Bank actually got cited and fined for having the mandate that employees show up before shift to do pre and post shift security procedures. And that was part of the not seeing eye to eye between Miss Robinson and myself, because Miss Robinson was like, oh, if you're not here by 7:55, you are late. But from the onset of my employment in 2017, it was 8 a.m. to 4:30 p.m., Monday through Friday. And there There are more times throughout my entire history of employment with the university that I was there before that time that was just left completely in the wind. I think that piece was hyper fixated on as justification for the university mishandling the entire situation. And I understand the assertion that, oh, the two aren't related. But I did my due diligence and I asked all the clarifying questions. I asked Ms. Tran if any of these actions or proceedings were going to be disciplinary, and I was lied to. That's clear as day. In the email excerpts that I included in my response. And as I wrapped up in my response, I'm not looking for some payout from the university system. I just want vindication that the situation was mismanaged, that those the university chose to put in leadership positions had messed up. And that's it. You know, it's been 2 years since I made the initial complaint. If I was looking for fame and glory or fortune, then I would have made a civil suit. I didn't. Because I don't care about the money. I don't care about a settlement. I just want the vindication to put myself at ease. That's all I have.
Thank you. Any commissioner questions for Mr. Ouellette? Seeing none. Thank you, Mr. Ouellette. Ms. Huey, you have 7.5 minutes.
So I guess the only thing I want to say is that from the complainant's presentation, what we hear is that he disagrees with his supervisor. He disagrees about when locks should be checked. He disagrees about the requirement that he arrive at work on time. And okay, but that's not discrimination, and that's the issue in this case. And that's all I have. Thank you.
Thank you. Commissioner questions for Ms. Huey? Seeing none. Thank you to both of you. Now we will turn to the investigator, Mr. Beauchesne.
Good morning, commissioners. Good morning, Amy. I don't really have that much to add to this particular case. Again, I would simply note that the performance issues noted none appeared to be related to the underlying disabilities involved, including the failure to complete tasks on time, the chronic tardiness that was unrelated to his disability, being seen asleep at work and during Zoom meetings, and having extensive discussions about personal matters while on the work clock. And again, in this particular case, if respondents were motivated to discriminate because of his disability, they wouldn't have gone probably with the performance improvement plans, which despite being viewed as disciplinary, were really a method and manner to hopefully allow complainant to improve his performance. But unfortunately, those didn't work to that effect either. So again, in this particular case, while the chronic tardiness can be downplayed, it's a realistic work expectation that you arrive to work on time, and complainant was counsel about this nearly constantly. So again, while the disability was present, and there were certain accommodations made in order to facilitate communication. There's no indication that any of the performance issues were related to his disability, meaning he was appropriately counseled, at least in my view.
Thank you, Bob. Commissioner, questions for the investigator? Seeing none. Thanks, Bob. So commissioners, we've heard from the parties and the investigator. At this time, we'll be looking for a motion or motions. Commissioner David.
I'll move that we find, I'll take them all together, that we find that there are no reasonable grounds to believe that respondent lawfully discriminated, that there are no reasonable grounds to believe that the other respondents interfered with providing a workplace free of disability discrimination, and if there are no reasonable grounds to believe that respondents, all of them, retaliated.
Is there a second?
Second.
It's been moved and seconded. Is there any discussion among commissioners?
Yes, I mean, I observed in my question, Mr. Willett says that he feels he was discriminated against, but he does not present in his own presentation a nexus between the points that he disagrees with his supervisors about being connected to a disability. Our investigator, Bob, I think he did an excellent job and a fair investigation. There's no notation of an independent investigation. He questions whether that's truly independent, but on top of that, there's a PIP. There's just no nexus to disability discrimination.
Any other discussion among commissioners?
I would just echo what Commissioner David said. For me, Mr. Willett, I appreciate your presentation. I appreciate you being here today. I think that where your claim fails is starting with the discrimination claim. As Commissioner David said, there's really no the nexus in the record between your disability and the performance related issues that your former employer has raised. And so for that reason, I think we'll be voting against your claim today.
Any other discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds on all three claims. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Ashby recused himself, so the finding are 3 votes in favor of the no reasonable grounds on all 3 claims. So the commission will send both parties and counsel a letter confirming that, that completes our hearing on the first case. Thank you for being here.
Next on the agenda is case number E21-0299. That's George Peterson versus State of Maine Department of Corrections Mountain View Correctional Facility. This is also no reasonable grounds case, and as a result, we'll hear from the complainant first or his representative.
I believe Mr. Peterson is here with us on Zoom. Mr. Peterson, I don't know if you want to put your camera on, but if you do, this would be a good time. Thank you. So you have 10 minutes to make your presentation.
Thank you, ma'am. As you said, I'm George Peterson. I worked as a Mount View Correctional Facility and Charleston Correctional Facility, correctional plant maintenance engineer 1 for, I believe, 16 years. I am going to go over Investigator Brindley's report and point out a lot of non-fact and missed information. Currently, I do not have a lawyer with me or anything like that, so I'm going to go over what was actually put out by my lawyer's last statement. During the issues of resolution conference on May 17th, 2022, Mount View witnesses provided several incorrect and misleading responses to questions in an attempt to cover up Mount View's retaliatory treatment of me. At the time, Warden Jeff Moran himself came out.
So can I
And-
ask you, I'm sorry to interrupt you, but can you not use the names of any individuals? We've given them other ways to refer to them in our report.
Yes, ma'am, I will definitely try.
Thank you.
Okay, the warden basically said that they were not trying to make anyone drive an uninspected vehicle. My background on this is I hold a motor vehicle inspection license for all vehicles except for motorcycles in the state of Maine. The individual and individuals, including the deputy superintendent, made quite a few untrue statements. The fact that the day after they were informed that the Mount View pulp truck was actually did not have an inspection sticker on it because I removed it and it expired. I provided the investigator and my lawyers with information showing a text message that come through to instruct another employee to drive the pulp truck about 30 miles to Bangor. I had to explain to them again, if you do this by email, you are putting this on the driver because he knows this truck is not inspected. And that began a bunch of retaliation shortly after that with quite a few nasty emails from the warden. I also believe that I definitely am a whistleblower because I am a licensed professional that reports to the motor vehicle inspection units. I am licensed, as I said, through them. And an inspection personnel calling a motor vehicle inspection unit and having them come in and check the shop is totally legal. I had heard you previously talk about private areas in the correctional facility. The area that this was in, the inspection was taking place, was not a private area. People come in constantly to deliver parts, everything. People come in and inspect things. It is well within my right, just as it is any individual sitting there. If you have an inspection problem with a vehicle, you can report a inspection station. I was directed not to do that, and I explicitly informed the warden at that time that that was not a lawful order to tell me I could not bring in an inspection unit. That is one of the ways that you can actually take care and keep yourself out of trouble by having them come in and go over your work. There are so many holes in this investigation that I do not have the time to cover them all, and I definitely want to reserve 5 minutes to go over whatever they rebut. So I would like to end it right now. I haven't covered nearly enough, but I'd like to keep the remaining time.
Sure. Thank you. You'll have about 5 minutes when we come back to you. But first, I'm going to see if commissioners have any questions for you. Commissioners, any questions for Mr. Peterson? Mr. Davis?
Mr. Peterson, do I understand that you're saying that you personally have a license that's at stake if you don't have a vehicle inspected in violation of a direct order by your superior to not call in an inspector?
I'm sorry. No, one of the 15 investigations that I got at the last year and a half that I worked at the correctional facility was actually allowing or having a motor vehicle inspector come in when when the warden told me specifically not to, and I told him that is not a legal order. It states right in the law book for inspections, main state inspections, that it is that a motor vehicle inspection unit will be available to be looked at by any motor vehicle inspector from that group to come in and look at paperwork, look at vehicles in question, anything like that during normal operating hours. I tried to explain this to him. He said no, and I still had the motor vehicle inspector come in because once again, this is my license. I'm responsible for any vehicle I put a sticker on, anything that happens. And basically, when someone else puts my work or questions what I do, I need to cover myself to make sure I'm doing the job properly.
Thank you.
Any other commissioner questions for Mr. Peterson at this time? Seeing none. Thank you, Mr. Peterson. We'll come back to you. I think then, Mr. Carter. You have 10 minutes.
Thank you. Good morning. My name is Jeremy Carter. I'm an Assistant Attorney General with the Office of the Attorney General representing Mountain View Youth Detention Center today, along with the Maine Department of Corrections. Throughout his employment with Mountain View, especially beginning around 2019, there were two things that were true about Mr. Peterson. The first is that he did occasionally bring some of his safety concerns to the management of Mountain View. The second is that Mr. Peterson unfortunately began to exhibit behavior towards management, his coworkers, inmates at the facility that was inappropriate, it was insubordinate, and it was disruptive to the workflow. As a result of some of those instances of inappropriate behavior, insubordination, and misconduct, he did receive a series of disciplines. He was investigated on several occasions for some of those issues. But that had nothing whatsoever to do with his reporting of safety concerns. It was part of his job to report safety concerns. His management wanted him to do that. That was part of his job as a plant engineer. As the investigator's report makes clear, in every instance of discipline, Mountain View justified that discipline with a legitimate, business-related, non-retaliatory reason. We encourage the commission to adopt the investigator's recommendation of no reasonable grounds for WPA retaliation and dismiss Mr. Peterson's complaint. As an initial matter, I will note that the investigator largely focused in the report on the failure of a causal link between the offered protected activity and the adverse employment actions. We completely agree with the investigator's findings there. As to the other elements of whistleblower claims, we do not believe Mr. Peterson has met those either, but we'll stand by our submissions in the record as to those arguments. So to discuss that causal link that the investigator spoke about in the report or wrote about in the report, the instance that Mr. Peterson has discussed here about the pulping truck used at the facility at the plant, that goes back to around October of 2020. It was his job to oversee this pulping truck. It was his job to make sure that it was up to inspection and that it was ready to be used at the time that it was needed. Unfortunately, what happened is that Mr. Peterson came to them rather late in the day and said, it can't pass inspection. I can't put an inspection sticker on it. There are these problems. Management said, okay, we understand that. We'll look into that. Mr. Peterson was upset because he wanted them at that time to spend money on the repairs needed for the truck. But management, given the short notice and the constraints of their finances, had to say, well, we'll have to assess that and go over that. They did not immediately authorize him to purchase the parts that he wanted to purchase to get the truck up to inspection code. But ultimately, they agreed with him that the truck was not up to inspection, and they were going to work on that. They just weren't addressing it immediately. In the meantime, he suggested that he, for no particular reason, was going to bring in a state inspector to inspect the truck after he had already done it and after management had already agreed with his findings. He said he was going to bring in the state police inspector to do it. No one was quite clear why he was going to do that. Mr. Peterson has suggested that it was not legal for the warden to order him not to do that. That is, of course, not true. The warden is the person in charge of the property at that facility. He has the right to instruct his subordinates how they will handle those trucks. Mr. Peterson was not at risk of losing his license. He had performed the inspection himself, and he wouldn't pass it. They understood that. They went along with that. So when he called in the state inspector, there was really no reason whatsoever for it. It wasn't whistleblower activity. He wasn't at risk of losing a license. He was just not following instructions. And that's what happened. And that was a source of one of his investigations and later disciplines. It was because he just brought this inspector in despite being told not to for no real legitimate reason. It was not unlawful for the warden to say, we're going to wait on repairing this truck. It was, of course, not unlawful. Some other instances that investigator Brindley looked at, there was an instance in December 3rd of 2020 when Mr. Peterson and several of, or I think it was 4 other colleagues, wrote a letter to management stating that one of the dump trucks at the facility that's used for sanding had safety issues. Once again, as is always the case when Mr. Peterson came forward with safety issues, they took this seriously. It's his job. He's an engineer. He's an expert on a lot of these things. They wanted to hear what he had to say. As it happened, on December 3rd, the same day that letter was sent, he received notice that he was going to be placed on administrative leave. It wasn't disciplinary, it was administrative because he had several outstanding investigations at that point, all related to misbehavior, insubordination, and poor conduct. He was placed on administrative leave the same day. The letter that he sent about the dump truck had nothing to do with the administrative leave. If you've had any experience in human resources, you will know that an administrative leave is not authorized for, on the same day that something happens, but in the most extreme of circumstances. There's a process. This administrative leave was already well in the works and set to be handed down that day before Mr. Peterson and his colleagues ever submitted the letter. They were unrelated, and investigator Brindley, I think, rightly noted that there is no evidence of a causal connection between those two things. Mr. Peterson was eventually brought back. He was eventually brought back. He did have some other investigations. He had some other written warnings. I won't belabor every single one, but the point is they were all justified for non-retaliatory reasons. Unfortunately, towards the end of his tenure with Mountain View, Mr. Peterson became a somewhat difficult employee to work with. He was often insubordinate. He often defied his supervisors. He was often unpleasant or inappropriate with his coworkers, both in email and in person. And Mountain View strived as hard as it could to resolve these conflicts without taking any really, really serious steps. Mountain View achieved that. Mr. Peterson retired, I believe, earlier this year. There was never termination. He was never suspended. He was never removed without pay. He was never demoted. Mountain View handled an unfortunate situation the best way it possibly could, and it never had anything to do with the safety complaints Mr. Peterson made. That was his job, and we appreciated that. Thank you.
Thank you. Commissioner questions for Mr. Carter?
Attorney Carter, you're saying that there was no adverse action taken against him?
Well, again, as I said, Investigator Brindley answered that question a little differently. We don't believe there was an adverse employment action because in whistleblower cases, the law actually states that there has to be a material change in employment circumstances. It's not the same standard as is used in a Title VII retaliation. So there was no material change in his employment. He was not demoted. He did not have a pay cut. He was never suspended without pay. He maintained the same position and the same pay the whole time. So we would argue, yes, that there were no adverse employment actions either, but we're more than happy to focus on what Investigator Brindley found, which was the causal connection element. But yes, that is correct, Mr. David.
Other commissioner questions for Attorney Carter? Seeing none, you'll have just over 3 minutes left when we come back.
Thank you.
Mr. Peterson, you have 5 minutes left if you want to turn your camera back on.
Yes, I would like to rebut what
Yep.
Mr. Carter said. First of all, I had not completed an inspection on that vehicle. I did what's known as a pre-check and walked around and just noted items. It was not a full inspection. Full inspection means I pull tires off, I pull wheels off, check brakes, I check everything inside. A pre-check is just to get the things so that you can say, I know I need this, 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 and this, without having to spend a good amount of hours, maybe a couple days pulling down a large vehicle like a pulp truck. I can also tell you that the Mount View administration and the prior supervisor, they changed supervisors in the Mount View area on the wood harvesting department just about the time that this was all taking place. The prior supervisor and I had discussed many times, and he had brought it to their attention that the pulp truck was going to need substantial money. Once again, I cannot keep vehicles inspected if I do not have money to buy parts. That's very simple. I can't manufacture the parts, I have to buy them. Mount View, in their own admission, has constantly had to hold off buying parts because of financial issues that they have. This was something that took place every year, even before I inspected the vehicle. The vehicle would run out of inspection, but yet they chose to investigate me and put charges on me on that. Many of the things that they put charges on me were as heinous as supposedly interfering with an investigation when there was none taking place that I was informed of. They tried to make it sound like I tried to change people's minds when I basically stated facts that were given to me from other individuals. This is a common practice for this area to like to pile investigations on people to get them to retire and get out of their hair. I'm hoping, given light of some of the things that have taken place in the last week, that maybe someone will take the time to look into this. I also, the safety concerns, one of them was about asbestos. I can tell you right now, there was asbestos in the steam plant. They put me, when I came back, I had none of the same duties that I had before. They like to say I wasn't a supervisor, but if you check the Bureau of, I'm sorry, the name escapes me, where we actually get our job descriptions in the state. If you look under that, under Correctional Plant Maintenance Engineer 1, they said that they did not put me back into a supervisory position, although none of the investigations had been completed, and I filed a Whistleblowers Act, and surprisingly enough, 2 weeks later, I was back to work with none of the prior 9 investigations actually completed. So that tells me that basically, whether the investigation was completed or not, I was guilty. They retaliated because I have made many safety concerns brought to their attention over the years and had to fight to get them to do it. When I got back to the boiler room where they placed me after I came back off administrative leave, which I lost a lot of money while being on, they put me in the boiler room, and lo and behold, the asbestos concern I had, within 2 weeks, they had people intubating asbestos out of the boiler room. That can be public record. There were many safety concerns, many concerns brought to the attention of the DOC commissioner and even in governor and email that I have brought to people's attention, and I was retaliated for because I basically was what they call in prison a rat on administration when they did things wrong. Thank you. I'm all set.
Okay, thank you. Commissioner, questions for Mr. Peterson? Seeing none. Thank you, Mr. Peterson. Attorney Carter, you have about 3¼ minutes left.
Thank you. Just briefly to the asbestos pipe situation that Mr. Peterson just referenced. Mr. Peterson first brought this pipe that he was concerned about to the attention of Mountain View Management in July of 2019. He claims that he was then retaliated against for having brought that concern, but there was never any discipline, never any investigation for almost 6 months later. And of course, it wasn't for the pipe question. So this idea that he was disciplined for the pipe, first of all, there was no discipline for 6 months, or there was no investigation for 6 months, no discipline for 9 months, and of course it was totally unrelated to the pipe question. The pipe was eventually changed, as is a routine process in the facility. Once again, this was a matter where supervisors didn't necessarily agree with his opinion that it needed to be changed, but they of course took it seriously and there was no retaliation. I think Mr. Peterson also just admitted that he well understood that there were financial constraints there, that when he said, I need X, Y, and Z parts for this pulping truck, he knew that the state couldn't afford it, or might not be able to afford it given the budget at that time, which is precisely why they told him to wait, which is precisely why they told him you don't need to bring a state inspector in. We understand. Even if all you've done is a pre-check, we trust your expertise. You've told us it can't pass inspection right now. Here's what it'll cost to bring it up to code. We get it. No need to bring the inspector in. When he defied that order, willfully and with several warnings, yes, he was investigated for that conduct, but that was it. It was not because he brought safety concerns to the attention of Mountain View. Again, that was his job. They wanted him to bring safety concerns to their attention, or at least it was part of his job. I can take any other questions. Thank you.
Commissioner, questions for Attorney Carter?
Yeah, I just want to wade into the adverse employment action issue just a little bit. And I'm looking at paragraph 6C of the investigator's report. It says that in August 2021, when complainant returned to work, he alleged he was demoted and stripped of his supervisory duties. Now, he was not a supervisor anymore, right? That definitely did happen, true?
He had some different duties that didn't involve supervising the same people he had before, correct?
Okay. It says here that his compensation and job title stayed the same, but also some of his duties were reassigned. I think that's what you just said. Some of his duties were different, right?
Oh, I'm sorry.
You go ahead.
No, I was just going to say that was as a result of the administrative leave. There were some of his duties that had to be reassigned for the operational needs of the facility in that absence to get things done, to move things along. And then when he came back, given his performance issues, given the way he had addressed other people, given the way he'd handled his coworkers, on top of the performance needs that caused the changes, it was decided that things would stay the way they were. But he had the same title, and he, of course, had the same pay. It's just some of the duties he had before. He was never supposed to really be a supervisor before. This just brought it back in line to what his actual job title was. It was just things like that in terms of the needs of the facility while he was out and in response to some of his behavioral concerns.
I don't want to get too far in the weeds here, but the job description for his position, the written job description, does it include supervisory duties or no?
It does not. I don't believe it does, no.
Okay, thank you.
Any other questions for Attorney Carter? Commissioner David?
No.
Is that you? Okay. Seeing no other questions, thank you. And then we turn to Alex Brindley, the investigator.
Ma'am, do I have a right to cross?
Do not, absolutely not. But thank you for asking.
Everyone, commissioners. My name is Alex Brindley. I was the investigator in charge of this investigation. So first, I want to discuss a concern that Mr. Peterson brought up in his initial presentation. He mentioned that he believed that the witnesses provided false statements during the Issues and Resolutions Conference. I would disagree. Based on what I experienced and based on my notes, I didn't get any indication that anyone was lying during the conference. But just generally to sum up my investigation, I mean, you can read this all through the report, but certainly I believed that Mr. Peterson established his prima facie case by showing that he reported his safety concerns. He was subjected to investigations and later some disciplinary actions. So he absolutely met the prima facie case. However, as Mr. Carter also stated in his presentation, I didn't find a causal connection between the protected activity and any adverse action. So for me, based on what I discovered during this investigation, reviewing the submissions, requesting additional information, and holding an issues and resolutions conference, it seemed to me that it was less about the protected activity of making safety reports and more about the fact that the complainant and the respondent disagreed about some safety concerns. Respondent told him that they understood his safety concerns, some of which they immediately implemented. Others, like the pulp truck, they decided they could not afford it. Any of the very costly repairs that were needed, and decided to, tell him to wait on these repairs. And instead of waiting as per his instruction, he contacted an outside facility as he was instructed not to. So really for me, it was the fact that the respondent disagreed with him, complainant then instead chose to go outside of his, not outside of his job duties, but in direct, he decided to go against what the respondent told him not to do, particularly in the matter of contacting the outside police inspector in the matter of the pulp truck. But I think, I think that's mainly what I wanted to bring to everyone's attention. But if you have any questions, I am available.
Thank you, Alex. Questions from commissioners for the investigator? Commissioner David, I'm sorry, Commissioner Thomas.
First of all, I just want to commend you on a very thorough report here. So thank you for that. In terms of you know what, I'm going to hold my question for now. My apologies. Yeah.
Any other? Yes, Mr. Ashby.
Hi. So I'm wrestling with something. Were they running this truck between June of 2020 and October 2020 on the road at a time when the complainant seemed to be suggesting that it was unsafe, or was it just sitting in the garage, not getting inspected because the resources weren't available to do it?
If I remember correctly, I don't believe it was in use. And even if it was in use, I don't believe it left the facility. Something that I learned through this investigation is that you don't need an inspection sticker when you're just driving it on the facility. You would need it to drive off-road on like main roads, but not on the facility. So that's all I got.
Maybe I'm not understanding the law or the case as well as I ought to, but if this complainant were concerned about the safe use of a vehicle, that the condition of the vehicle made it unsafe, and yet it was nonetheless in use, I mean, that is what whistleblowing is all about, right? Calling an outside agent and the cops or the law enforcement or something, and saying, hey, there's a violation of the law happening here. And the complainant, I think, is going to argue that that's what he was doing. But I do think there's a big distinction between him doing it at a time when the truck is sitting idle and the respondent is saying, we're not going to put the money into the truck, we'll just let it sit until we have the money available to do it. And there's a big difference between that situation and the truck being on the road. And I guess I wasn't 100% clear from the investigative report which of the two it was.
Certainly. So for your first matter, I don't disagree that the complainant, arguably engaged in protected activity when he made his safety concerns. That's what the WPA Act is. But if I do remember correctly, and the file was quite substantive, but I do think that the reported vehicles were not in use, especially there was the matter of the sand truck. I don't think that was in use at all because they had to install it.
Mr. Peterson, I see you wanting to make a comment, but we're not hearing from the parties at this time.
All right, thank you. Alex.
Nope, Mr. Peterson, nope. We do not hear from the parties at this time. I appreciate that you want to add something to the discussion, but the party's opportunity to offer information, that time is over.
I'm
sorry.
I have information related to those questions from the commission.
I don't know who you are, but this time we're not taking new information. The file is, the evidentiary record is closed, and that is the information on which the investigator made their decision. We don't accept new information at this time. Commissioners make their decision based on the information in the evidentiary record that the investigator considered. Are there any other additional commissioner questions for the investigator? Seeing that, thank you.
Thank you.
So commissioners, you have heard from the parties and from the investigator. At this time, we would be looking for a motion or motions. There's one proposed finding.
Well, I'll move that we find that there's no reasonable grounds to believe that the state of Maine retaliated against petitioner.
There a second? Second. So it's been moved and seconded to find no reasonable grounds to believe that the Maine Department of Corrections Mountain View Correctional Facility is subjected complainant to unlawful whistleblower activity. Is there any discussion among commissioners?
I share Commissioner Hackby's concern, and I had that same concern myself, but I wind up having to go with the investigators' understanding that this seems to me we would know clearly if the facts were that Mr. Peterson said, I'm not inspecting that vehicle, and they said, okay, we're driving it anyway, unsafe or not. They said we can't fix it now. They didn't fix it. They didn't get a sticker. It doesn't seem as though the disobedience in terms of him it's like he's trying to prove a point that nobody's contesting, that it's unsafe and it's not going to get a sticker. So I'm not finding the connection between his job duties of safety concerns and inspections resulted in retaliation for reports of those conditions.
Any other discussion from commissioners?
I think this is a tougher case than it's been made out to be. I do. I share Commissioner Ashby and Commissioner David's concerns about, the characterization of what this man did. I mean, this is what whistleblowers do, as Commissioner Ashby said. They raise issues that they feel need to be raised. And if you have a safety issue and your employer says, for God's sake, don't contact this outside person, and you do, I think that's what whistleblowers do. I think that where the case comes down is the nexus. And admittedly on this record, it's kind of hard to determine, because there are so many written reprimands for different reasons and so on and so forth. So I just wanted to put it out there for Mr. Peterson's benefit that I think this is a tough case.
Any other discussion among commissioners? So then, the motion is to find no reasonable grounds for any unlawful whistleblower activity occurred. If you vote yes, you are in agreement. Commissioner Ashby?
Yes.
Mr. David?
Yes.
O'Brien? Yes. Mr. Douglas?
No.
So the finding is no reasonable grounds, and the commission will send the parties and attorneys a letter confirming that, and we thank everyone for their participation in the hearing.
Are you done? You're all set?
Yeah.
Sure, you need a break. The next case is ED 21-0317AB. This is a reasonable grounds case. That's Dennis McAllister versus McAllister Towing and Transportation Inc. and the Portland Tugboat LLC. I understand we'll hear from respondents attorney.
Silver, I can provide this exciting new gadget for you.
Okay.
Try not to roll your eyes.
Yeah, I appreciate that.
Oh, I have put a clock up here too, so.
This is really interesting for me.
Yeah, I think a redundancy might be a good idea.
Are you, yeah, I'll do my timer too. Are you representing both respondents?
Yes.
Okay, let's see what happens with this.
All right, good morning. My name is Steve Silver from Littler Mendelson, and I represent both respondents, Portland Tugboat LLC and McAllister Towing and Transportation Company. I'm here today to ask you to overturn part of the investigator's report, finding reasonable grounds that age discrimination occurred. Portland Tugboat is a small, family-run Maine company with less than 20 employees, many of whom have worked for the company for decades. Such is the case here. The complainant and his boss, who I'll refer to as BF, who's the president of Portland Tugboat, have worked together since 2001. Now, 20 years later, on the morning of June 2nd, 2021, complainant was on the Portland dock and called a coworker who was in Belfast to complain about his boss. Complainant likely thought that BF was away on a trip to California. However, BF had stopped at the dock on his way to the jet port, and upon entering the dock, overheard complainant yelling about and disparaging him. BF was understandably upset, because here is what complainant said. At the Issues and Resolutions Conference, complainant admitted to doing the following while on the clock. 1, he called his coworker to complain and criticize his boss. 2, he questioned his boss's decision to send another employee to California. 3, he falsely accused his boss of assaulting that employee. And 4, he accused his boss of embezzling company funds. BF could not believe what he heard, and he was justifiably upset. He confronted complainant and told him to hang up the phone and apologize. When complainant refused to apologize, BF admittedly overreacted and fired him. But there's quite literally nothing about age here, right? BF acted in the heat of the moment. And we know the decision maker's mindset because we actually have a text message sent within a few hours of the firing. See, after the confrontation, BF headed to the jet port for his flight. But after cooling off and cooling down, he sent the text, which is Exhibit 3 to the respondent's position statement. But it's about 2 hours after the confrontation. He wrote, "Dennis, I think we were both in bad moods this morning. I don't want you to go anywhere. Your health insurance to us is too important to you and your family. I will pay you for today and tomorrow. If you want to come back on Monday, I'll leave your pass and card key on desk at the security office." BF was in a bad mood and overreacted to hearing a subordinate disparaging him. His heat of the moment decision to fire a complainant had nothing to do with age. And that text is exactly what we want employers to do in Maine. Recognize when an error is made and correct it. But this is where the investigator's report makes a significant error. The investigator concluded, quote, "Complainant established that age was a motivating factor in his discharge, and respondents failed to prove that it would have discharged complainant even in the absence of this unlawful motivating factor." This ignores the substantial record evidence in the form of complainant's own statements, establishing why BF got angry that morning when BF wasn't even supposed to be on the dock, right? He overreacted. It's really hard to imagine any employee being able to criticize and denigrate their boss without facing some sort of disciplinary action. BF was upset that one of his employees would speak about him on the clock in such an impressionable manner to a coworker. BF was even more upset when complainant refused to apologize. As a result, BF fired complainant. age played no role. Whether complainant was 19 or 90, BF was going to have the same reaction. And he told the investigator that. To conclude that respondents failed to prove it would have discharged him otherwise is just a misreading of the record. Additionally, the investigator never analyzed the fact that BF is in the same protected age category as complainant. At the time of this incident, both of them were over 50. This alone cuts against the finding of age discrimination. And not only was BF in the same protected age category as complainant, but they never replaced complainant. Instead, on 4 different occasions between June 2021 and most recently in December 2022, BF tried to rehire complainant into his former position. It's illogical that BF would fire a longtime employee for being too old, but then leave the position vacant and seek to rehire. The investigator just glossed over these facts. Now, despite the record establishing that BF discharged complainant for his behavior, not his age, the investigator fixates on a single alleged stray comment to find reasonable grounds. Complainant alleges that BF told him, "You need to retire." BF recalls saying, "You need to go, you're fired." The coworker on the other end of the phone says she heard the boss say, "You're done, you need to retire." So that we get 3 different versions. But the single remark, even accepting it as true, "You need to retire in the heat of the moment," is not enough. And there's a lot of case law on that one comment put in context is not enough to establish either the prima facie case or pretext. And I don't want to overly criticize the investigator because he was put in a difficult position. He didn't conduct the IRC. So he didn't have an opportunity to meet or interview the complainant or BF. He had to come in at the 11th hour and make a credibility determination based on someone else's investigation. That's really hard to do when you haven't met the parties. But there's a lot of factual things that the investigator missed, one of which is the complainant said he was on the phone for 5 to 10 minutes and the coworker was on the phone the whole time. Now, BF said that's not true. He hung up within a matter of seconds and the coworker backed BF. He said, "No, I only heard a few seconds," and he hung up the phone. That's a critical fact. Additionally, complainant said at the IRC that BF told him on multiple occasions, "You need to retire." And he said the office manager would back him up on that. But when the office manager was interviewed, she said, "I never heard him ever say that to him or other employees." And that's why the investigator found no reasonable grounds on the hostile work environment claim. So it's hard to square those two when you've agreed with the office manager that BF never made these comments over the years. But here, acting in the heat of the moment is somehow age discrimination. Complainant's sworn complaint also makes false allegations about other employees. Complainant in his charge, right, which he signed, made specific allegations about BF's treatment to another coworker, BR. But BR read the whole charge, went allegation by allegation, denied every single thing, provided a sworn declaration, and the investigator doesn't even make reference to that. Now, lastly, and this is a bit more procedural, McAllister Towing is not a proper party here. McAllister Towing did not employ complainant. The record proves that Portland Tugboat hired complainant on December 22nd, 2001. Since then, Portland Tugboat remained complainant's sole employer. All of the pay stubs clearly identify Portland Tugboat as complainant's sole employer. Furthermore, McAllister Towing played no role in the decision-making process, right? BF acted alone. BF unilaterally made the decision. McAllister Towing was also not involved in the day-to-day operations of Portland Tugboat and wasn't involved in the day-to-day employment of complainant. So there's no reason why they should have remained apart here. So to the extent that you do uphold reasonable grounds, when you go to vote, I'd suggest that you split out the respondents. Thank you. I'm happy to answer any questions and I'll reserve the rest of my time.
Thank you. Questions for Attorney Silver?
Really enjoyed your comment about you can't expect that if you denigrate your boss, there's not going to be some sort of adverse employment action. Perhaps you don't have any paralegals in your office. With respect to this.
And I work remotely a lot, so I probably do make a comment.
Yeah. Yeah. Maybe it's just me. in terms of the sort of mixed motive analysis employed by the investigator, these other comments, right, that are alleged to have been made in the past about how, you know, people get to a certain age and they need to retire. There's an allegation that this company had a history of trying to force people out when they get to a certain age. And I guess there were sworn affidavits either way.
Well, if I could jump in.
Please, yeah.
And the investigator did have a sentence in the report saying each side provided sworn affidavits supporting the position, except the affidavit complainant presented was unsworn, wasn't notarized, unverified. So it's practically worthless. And complainant filed his charge. He waited till after the IRC to present this affidavit, which is curious in itself with the timing. But I think what's even more interesting is that all these employees that he listed in the charge of being fired or forced out, almost all except for the one he got the statement from, they're still working within the McAllister companies. Now, McAllister, the parent company, one including BR, who complainant says, "Oh, he was forced out. He was forced to retire." He said, "No, I asked, can I go work in Virginia to be closer to family?" He's still working. So there's all those allegations were false, which I think supports why there was no reasonable grounds on a hostile work environment.
And it wasn't clear to me from your presentation. Are you contending that this statement about retiring, you need to retire or whatever he said, you're saying that was not made?
I'm saying for purposes of today, we can assume it was made.
Okay.
I'm going to concede that. I have to go with what BF said, but look, we have a witness, right, who said it. So put it in context, right? He hears this, he overreacts. We know he overreacted because he said in the text, "Well, we were in bad moods, pulled off." And instead of saying, "You're fired, you need to retire," you know, he used it. But to somehow impart age discrimination on a heat of the moment thing, that this was somehow plotted, the guy wasn't even supposed to be there. Like, he stopped at the dock to pick something up and overheard this. And admittedly wish it didn't happen, which is why he sent the text within 2 hours saying, "I'll pay you for the extra week, come on back."
Right. And just one more thing, this business about these folks being the same age, right? I mean, just because you're in the same age bracket,
Certainly.
that doesn't mean that you still can't discriminate against folks on the basis of age, right?
Absolutely. But obviously, you probably know the cases I would cite that would say it's evidence that discrimination did not occur, right? It's not dispositive of it. But that's a key fact.
All right, thank you.
I had the same reaction to your first statement about if it's in the same age category. I don't think that's relevant as to whether he thinks complainant is too old to be captaining the vote. But it seems to me significant. What is your reaction to me saying to you that the use of the word retire is just directly related to age? He doesn't say you're fired for insubordination or insulting or something like that. And the fact that he's not scheduled to be on the call, I think cuts the other way, that age has been on his mind. And the allegation is that he's urged out 2 other over 60 employees, and the respondent is now perceives himself to have be a target because he is the oldest.
Well,
and he uses the word retire. You need to retire.
sure. So a couple of things, if I can unpack that. One of which is these allegations about others, and over the years, complainant said, "This witness will verify that." And that witness said, "I've never heard him say that. This is actually the first time I've ever heard BS use the word retire." She told the investigator that. So that's complainant's, proof right there. Another one of those employees who was allegedly forced out is still working. He's not working for Portland Tugboat, but he's in the McAllister family of companies. He asked to be transferred and they granted him that. So when you put that in context of here's this, kitchen sink approach of allegations, we disprove them one by one. And yeah, he used the term retire. If that's enough, that's really difficult, right? He said you need to retire. If he said it, it was in the manner of you need to go, you're fired, you're done. And we have 3 different versions of the actual phrasing used But I think it cuts the other way. You say it's on his mind, so that's what came out. I think he reacted in the heat of the moment and he used a phrase, which, believe me, he regrets doing. This is a long-term employee he's known actually since the 80s, right? They've worked together for 20 years. They fight like brothers, okay? BS dad was his employer for a while. So these guys have a history and they're working on the docks. They're working in tugboats. Okay, they're not in suit and ties in the office. So that's why once he sat down and thought about it, that was stupid. That was overreaction, right? Probably didn't even warrant a warning at that point. Just, hey, I overreacted. Come on back. I'll pay you for the rest of the week. Come on back.
Another question about the relationship between the companies. I was impressed with your argument when I read it that we ought to find that they're different. But then in the response that you just gave me, you said the other employee went to someplace else in McAllister.
Yeah.
Are they connected or not?
Well, it's a parent company. So McAllister has dozens, I don't want to say hundreds, but at least dozens of different companies that all operate in this network with the boats.
But they're connected enough for that parent company to know that employee and to know, fine, we'll accept his record and his experience and we'll put him in Virginia.
Well, you have to apply for a position, right? So he says, is there something in Virginia? The head of Portland Tugboat will call McAllister and say, are there any openings close to Virginia where his family is? And then he applies and he gets hired, So, I mean, that would really change the law on imparting liability to parent companies, particularly when in this case, there's no day-to-day control. And they played no role in the decision and they don't pay him, right? I mean, he was hired, right? We have the hiring report from Portland Tugboat, every pay stub, Portland Tugboat. McAllister didn't even know this happened, right? Until the charge comes up. And there's a lot of good case law from the First Circuit about even if there's providing administrative or HR resources, that's not enough to impart liability. They have to have some control of the day-to-day operation.
Did BF also work for McAllister?
No, Tugboat.
No connection.
He's the president of Portland Tugboat. He's not paid by McAllister.
Okay. Thank you.
Any other commissioner questions? Yes.
I really thought your brief regarding the stray comments issue was good. It was really good. It was helpful for you to provide examples from the circuit about the comments. I got to tell you, I was kind of surprised at some of the cases you cited about people getting summary judgment in situations when it seemed to me the employer made very discriminatory remarks. So I thought that was really, I thought that hit as far as the brief goes. And you would agree with me, would you not, that if it's not a stray remark, but in fact a series of remarks by the respondent, that argument isn't as strong, right? I mean, obviously the stray remark argument is good because right, you got to be straight.
Yeah.
But would you also agree you don't need to have enough remarks for it to become a hostile environment in order for you to get out of the stray remark defense and still face liability? I mean, because I know you argued in your argument that, and the investigator didn't find hostile environment, so therefore it's a stray remark. And I'm not sure that I agree.
You can have a hostile environment off of one comment, right? I mean, if it's severe enough, depending on what it is. But what and maybe inartfully said, right, is trying to look at, we have allegations of, for decades, this guy has been doing this to employees, right? And complainant listed very specific employees with direct quotes, direct allegations. We went back, disproved them, right? His key witness, the office manager, said, BF has never said that. I've never heard him use that word ever, right? And she's worked there the whole time too, for 20 years. BR, this employee who was allegedly forced out. Nope. Provided a sworn declaration. I'm still working. BF never forced me out. I'm the one who asked the limit. So when you disprove all of those affirmatively, coupled with the fact that there's no evidence that any remarks about retiring or age were made over the years or repeatedly, this is the first time, right? This is that isolated comment. And I don't think it rises to the level of, if you use certain slurs or certain things once. That could be a hostile environment. But that's not the case here.
Any other commissioner questions for Attorney Silver at this time? See, now you have just over 2 minutes left. For a complainant, we have Attorney Dietrich.
Thank you. Is it okay if I take my mask off?
Yes, I forgot to tell Mr.
So people can see my mouth move. I know that's sometimes meaningful for folks. Good morning, commissioners. My name is Amy Dietrich. I'm here to represent the complainant, Mr. Dennis McAllister, who's sitting behind us in the teal shirt. He drove up to be here today. I am here in large part to urge you to affirm Investigator Beauchene's report and the recommendation that there's a reasonable grounds finding in it. I prepared some remarks today in advance, which are going to sound as though I drafted them just in response to a few specific questions, but I think that's because you are already keyed into exactly the reasons why this case should be issued a reasonable grounds finding. Mr. McAllister is a man in his mid-60s who, as Attorney Silver stated, worked for Portland Tugboat for 20 years. As Mr. McAllister put in his complaint, and as Attorney Silver said, Mr. McAllister worked for the, I think the phrase he used several times was the McAllister family of companies. And this is a significant phrase because one of the primary pieces that the respondents objected to in their report is that they should not be lumped together. The argument on this point is that they are not a single company. But that's not the law. That's not exactly what we look at in the employment context. What we actually look at is whether the respondents are joint employers, meaning that they have, based on a series of factors, significant enough interrelation such that for employment liability to attach, that they are his joint employer. Those factors are actually reflected in my briefing for a case you're going to hear from me again on in about 2 cases. But those factors are from the Supreme Court of Maine. They are whether there are interrelated operations, common management, centralized control of labor relations, and common ownership. Here, as Investigator Beauchene found, there's sufficient evidence in the record to establish that there's at least an even chance the complainant will be able to prove in court by preponderance that the respondents were his joint employer. The operations of Portland Tugboat are interrelated with that of its parent company, McAllister Towing. I should say McAllister, that's actually not related at all to Mr. McAllister's name. That's just a coincidence. There's no relationship. There's 1 L in his name and 2 L in the company. I should probably clarify that. McAllister Towing provided HR support to Portland Tugboat. In addition, there are several employees that even respondents would admit transferred between different entities in the McAllister family of companies. So you heard reference to an employee named BR that we'll get to in a minute, but BR transferred to the Virginia location of one of the McAllister family of companies. Likewise, there are 2 more examples of employees in the record in the response that respondents filed. One, they transferred to the Baltimore company, and I believe one transferred to a Philadelphia company. And transfer is the important word here. There's no actual application to transfer. People just move between companies. Investigator Beauchene, in his report, I would say accurately, found that they are sufficiently intertwined that the commission could issue a reasonable grounds finding against both entities. And of course, there is common ownership because Portland Tugboat is owned in its entirety by McAllister Towing. With respect to the age discrimination, the factual pieces, you've heard a hyperbolic and wild exaggeration of a conversation Mr. McAllister had with the office manager that resulted in his termination. Now, The reality is that conversation was short and perfunctory on Mr. McAllister's end and respectful. He was, contrary to what you heard today, Mr. McAllister in his sworn complaint explained that he called the office manager to schedule some time off. He hadn't had any time off in 2021. And so in response, the office manager asked him, well, where is employee X? Because there would be coverage issues. So he said, well, I don't know where employee X is. It turns out that employee X was somewhere else doing something for BF, the boss. And that is when Mr. McAllister made the comment about, well, I'm surprised he's doing that because he was assaulted by BF. Now, it should be said that the reason why this employee X was not going to be in the state of Maine is doing a personal errand for BF. This had nothing to do with work, but it was relevant to ask why that employee wasn't there and to have that conversation. From that brief conversation, Mr. McAllister, and I'll call him Mr. F or BF, told him that he needed to retire and then fired him. You heard from Attorney Silver today that there are 3 versions of that conversation. There are actually only 2. There is what Mr. McAllister swore to in his complaint, that his then boss, Mr. X, said you need to retire and then fired him and you need to go. That is exactly, in words and substance, what the office manager, who is still a current employee of Portland Tugboat, affirmed happened. Contrary to the sworn affidavit that Mr. F filed in the case, and contrary to what he told investigator Beauchesne, well, I should say the previous investigator, but investigator Beauchesne listened to that, and I presume found that meaningful, that there was a denial under oath 2 times by Mr. F, but the office manager, at risk to herself, actually affirmed what did happen. So there are actually only 2 versions of that conversation. More to the point, respondents assert that there's only one stray remark by Mr. Fournier about, Mr. F, about Mr. McAllister's age when he was terminated, and that's insufficient to establish liability. Now, this myopic emphasis ignores the fact that Mr. McAllister endured years of age-based comments. They're in the complaint, but I'll just highlight them very quickly. Mr. F told Mr. McAllister 8 to 10 times, you really need to retire, you really need to get done. And then, Dennis, you got to plan your retirement. You should be thinking about retirement. In response to hearing that Mr. McAllister wouldn't shovel snow because that wasn't his job as a ship captain, Mr. F said, well, then, you know what, you need to retire. And Mr. McAllister is not the only employee that was on the receiving end of a number of these comments. Mr. F told other employees, SB and BR, who are both in their early 60s, that they would be retiring that year, even though they had no plans to retire. A few months later, he told SB again in front of Mr. McAllister and others that he should make plans to retire and ask when he was going to leave. Now, SB did file a declaration that's in the record in this case. The respondents make way too much hay about the fact that he didn't sign it in front of a notary, but he did sign it by his own free will and deed. He said that it was true to the best of his knowledge, and he signed his name there. I would say to you that that is powerful information that I know that the investigator reviewed and that I would hope the commission would credit as well. In addition, moving on to the other not stray remarks, establishing a pattern here of, an obsession really by BF with getting older employees out of the company. Mr. F told Mr. McAllister and another employee, EH, that 62-year-old employee, BR, was unsafe because of his age and health, even though his health was not a problem or obstacle to him doing that. And then Mr. F refused to train another older employee for a docking pilot position because he was too old. And Mr. McAllister also recalled that Mr. F began targeting the oldest employee of Portland Tugboat, BR, with comments like, you're too old, you got to plan your retirement. And BR told Mr. McAllister that he was told this by Mr. F back when it happened. Now, this is the employee that Attorney Silva referenced filing a competing affidavit. That competing affidavit, well, I should say that BR is currently still an employee of one of the McAllister family of companies, and the affidavit is quite obviously drafted by somebody in Attorney Silver's office. Pointedly, even if we credit that affidavit drafted by counsel as being the statements of BR, he does not deny under oath that he told Mr. McAllister that that happened back when it did happen. Nor did he deny under oath, nor did Mr. F deny under oath that Mr. McAllister confronted him about this pattern of presuming older workers to retire by saying, "You can't force people to retire," to which Mr. F responded, "I can do whatever I want." In sum, there's not simply one stray remark in this case, either to Mr. McAllister or to the other older employees. There is certainly one remark that was made during the conversation in which he was terminated, but that one remark has to be looked at as part of a longer series of comments. I saw in the response, and I also heard it repeated today, that Attorney Silver said that whether Mr. McAllister was 19 or 90, that Mr. F would have said the same thing to him.
That's your time. It was supposed to be, but it didn't.
Okay, well, I guess we ran into the problem with that. Thank you.
And I'm sorry to interrupt you. Commissioner questions for Attorney Dean?
I'm just curious. The unsworn affidavit. Why unsworn? I mean,
Because he was in Florida when we were putting that together.
I enjoyed your comment about the affidavit was drafted by counsel. Is that 98% of all affidavits submitted in a case are drafted by counsel?
Absolutely.
Affidavits. Okay. Those are my questions. Thank you.
Any other questions from commissioners?
There's no personnel policy in the company that touches on age or retirement.
Not to my knowledge.
And your presentation seems to me to be broader than I thought it was in terms of BF wanting to urge out people over 60. I thought it was just the tugboat captains, people on the water. Is it?
It is broader than just the few employees that Attorney Silver touched on. There were a number of older employees that were eventually encouraged to retire and did retire.
Thank you.
Other questions from commissioners?
One more question. The main law court case that you cited, the different entities, what was the name of that case, please?
It's in my briefing and I'll talk about it again in about a half an hour. It is the Ostrowski versus First Portland Mortgage Corporation Company decision from 1995.
Thank you.
Additional commissioner questions for Attorney Dietrich? Seeing none, thank you. Attorney Silver, I'm going to tack a few extra seconds on there to compensate for the lack of a beat.
Okay. All right.
About 2 minutes and 15 seconds.
Thank you. Yeah. Two things. One, if you turn to page 2 of my objection, you'll see a whole bunch of case law. The First Circuit in 99, so after the case that counsel cited, said a parent company cannot be held liable for its subsidiaries' alleged misdeeds unless there's, quote, strong and robust evidence of parental control over the subsidiary, rendering the latter a mere shell. Direct quote. That's not what's here, right? BF runs a small Portland tugboat by himself. He controls the day-to-day operations. They issue the paychecks. The counselor does not control the day-to-day operations of the company or the day-to-day employment of the complainant. So to claim otherwise just distorts the record here. And yes, there are some HR resources available because complainant, one of his allegations was, well, I couldn't go to the boss and I couldn't go to the office manager. Well, there is HR backup from McAllister. And again, First Circuit says the mere use of common human resources does not make the parent company liable for the actions of its subsidiary. So this is just well-established law. Now, in the remaining minute, let's back up to what council wants you to believe. That complainant walked into the dock, perfectly calm and professional, had a nice conversation. And BF just showed up and went off the handle and fired the guy for no reason other than age. That is not believable, right? And then the text, just 2 hours later, why would he send a text saying, hey, we were in bad moods, I cooled off, I don't want you to go anywhere? Why would he say that if there was nothing wrong with the phone call? It's just a pleasant, polite call. And it just defies logic. And that's what we have here, right? We have all these allegations thrown against the wall, which have been disproven, not supported. And there's one comment, happened in the heat of the moment. And it defies logic that BF would just fly off the handle and fire someone he's known for nearly 40 years, worked together at Portland Tugboat for 20 years, because there was a perfect, quiet, calm phone call. Just doesn't add up. Thank you.
Commissioner, questions for Attorney Silver?
Being none.
So then we turn to Investigator Beauchene.
Morning again, everyone. Just to touch on a couple of points here. While I did not have video of the IRC, I did have a complete audio recording that was available to me. I also decided to hold a post-IRC witness interview with the one person who I hoped could resolve the primary dispute, which was whether or not the word retirement was brought up during that final conversation. Upon interviewing that witness, again, while denying that she had ever heard that term come out of the owner prior to that day, she was very clear that at the conclusion of the telephone conversation, just prior to telling complainant he was discharged, that he needed to retire. And for me, again, whether or not that was what he meant, whether or not that was actually a factor in his heart, I certainly can't answer that. All I can go by is that while a straight comment in and of itself over the course of employment might not justify a finding of reasonable grounds, the fact that this comment was made almost simultaneously with the discharge decision, for me, got complainant to the reasonable ground standard of at least a even chance of prevailing were this matter to go to trial. So I was unable to resolve or come to a definitive conclusion about the other remarks allegedly made about other older employees over the years. However, for me, the fact that the retirement comment was made at the time of the discharge was enough to get him to the reasonable ground standard, in my view.
Any commissioner questions for the investigator?
So good morning again. And actually, before I launch my question, I just want to say again, this is an excellent report, very detailed, very helpful. So thank you for that. In terms of the robust control that the council alleges is necessary to hold parent company liable, I just wondered, had some competing presentations here on the amount of control exercised. Respondents council says, and cites case law saying that the sharing of human resources is not enough. You need something else. And I'm just wondering if you wanted to comment on that.
Well, again, I think that particular issue was addressed in a footnote, so I will defer to legal counsel as far as why the additional company was included as a respondent in this case. Again, it was my understanding that at least at this stage, that there was enough of a commonality between the entities that was considered to be both legitimate respondents. But
You're just gonna stare at me, or do you have a question?
I know what my question is.
The question is, would you like to comment?
I wouldn't particularly. That for a minute.
I mean, I've read with the, so, I mean, this is what we have in terms of,
I'm not gonna lie, the record in these cases where there are related employers named often the record on that issue is not particularly well developed by the parties. They're focusing on the discrimination allegations. So we do the best we can with what's in the record. And in this case, there appeared to be enough intermingling of functions and the transfers that were happening all led to, and again, it's just a preliminary investigation, led to the conclusion here that there was enough for us to move forward against both companies, keeping in mind that we understand that there will be a higher level of proof required if this case should go to court. But again, it's never the primary focus for the parties. So we just piece together what we can from the record.
Thank you, counsel.
I make a statement on that.
Nope.
Look at the records.
I have a question for council about age discrimination. Can you have a company policy that has a mandatory requirement age based on, for instance, airlines and I think pilots that, you know, you're over 75, we're concerned about your reaction time landing the airplane. So you have a mandatory retirement.
That's actually in the statute, but I don't remember off the top of my head. And I don't think it's relevant to this case. I can certainly find out for you. I just have to read the statute because it's not something that gets referred to a lot.
I think there are some safety sensitive.
Yeah. But in general, can your average kid, is there a requirement? I think that would be challengeable.
Other questions for the investigator?
Or me.
Distinguished legal counsel.
Any questions for you?
Any related to this case?
Seeing none, there are two proposed findings. You may want to take them separately. Is there a motion or motions?
I'll move that we take them together. And that we adopt the investigator's findings that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of age by discharging him, and that conciliation should be attempted, but that there are no reasonable grounds to believe the respondent discriminated against complainant on the basis of age by creating a hostile environment. That part of the claim should be dismissed.
Is there a second? So it's been moved and seconded to find reasonable grounds on discharge based on age, no reasonable grounds based on hostile work environment. Is there any discussion among commissioners?
I'm just going to be really brief. My questions asked of counsel suggest my reasoning. I think this is a stray comment plus. I think that there's at least an even shot that the complainant's assertion that there were other comments made, behaviors on the part of the respondent that take it out of the stray comment category. I do think it's a very, very close case, but that there's at least an even shot.
I tend to agree. I'm fairly clear about the age discrimination. I think that comes through, and I do focus on the word retirement kind of thing. I'm more troubled by the two companies together, but I think I will support the motion based on counsel's answer that that's what they had and the parties didn't focus on it.
Other discussion among commissioners? Seeing none. So the motion to find reasonable grounds is discharge based on age, no reasonable grounds for hostile work environment based on age. If you were in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
So one reasonable grounds, one no reasonable grounds. The commission will send parties and council a letter confirming this, and we appreciate your participation today. And before we move on to the next case, I'm going to just get Commissioner Douglas's lunch order so I can call those in. Didn't think I was going to do that, did you?
I missed the email about lunch.
I texted you, there was no email.
Yes.
I texted you,
Oh, I didn't see the text.
so I didn't text you it because you gave me.
Oh, that's right. Can we take a minute? Right, fine.
Excuse me, how long is the recess? You're,
2 minutes, sorry.
thank you.
Already, our next case, we have folks online ready. All right, our next case is number E21-0400 A and B. It is no reasonable grounds case, Thomas Barnes versus Huber Engineered Woods LLC, Charlotte and of Easton. I'm going to recuse myself from this case as well, and so I'll sit back with Roland. But we are going to hear from complainant or his representative.
Yeah, I believe Mr. Swanson, Attorney Swanson is here for complainants.
That's correct. Good morning.
You guys still have 10 minutes.
So my name is Adam Swanson, and I represent the complainant, Thomas Barnes. Mr. Barnes is here in my office with me observing the proceeding. The respondent, Huber Engineered Woods LLC, operates a plant in Easton, Maine, and employs approximately 135 people. Mr. Barnes disagrees with the investigator's recommendation that a finding be made that there are no reasonable grounds to believe that respondent discriminated against him, and asks that that recommendation be overturned. This matter arises as a result of respondent's failure to engage with complainant in an interactive process and to provide a reasonable accommodation. Mr. Barnes was 22 years old when he began working for Huber as a shift electrician. He earned multiple promotions over the years, including one to his final position before termination of equipment specialist. Approximately 2 years ago, a new maintenance supervisor became his department manager, and Thomas reported to that manager. Mr. Barnes was given a poor review on February 8th, 2021 by this manager, who asserted to Mr. Barnes that he had poor communication skills. Mr. Barnes is diagnosed with post-traumatic stress disorder, PTSD, and major depressive disorder, MDD. These conditions were caused by a traumatic event that he witnessed while serving in the United States Army and before being honorably discharged. These diagnoses are directly related to his poor review for communications issues. During his review in February of 2021, Mr. Barnes explained to his manager that he suffered from PTSD and MDD, which were both diagnosed by a doctor, and that it was very difficult for him to approach others with issues, especially if it might result in any type of confrontation. It was a symptom of his conditions, along with anxiety, depression, fear, worry, hypervigilance, and issues with intimidating people. When Mr. Barnes and his manager met for future reviews, the meetings did not go well, and his manager's aggression toward Mr. Barnes triggered his PTSD and MDD symptoms, and Thomas would essentially just shut down. On Friday, April 23rd, 2021, Mr. Barnes was called into his manager's office. When he walked into the office, the manager asked him to close the door, and then immediately began swearing loudly at Mr. Barnes, belittling him, intimidating him, and threatening him with a demotion. The meeting ended when he told Mr. Barnes to get the hell out of his office. Mr. Barnes did just that, and he went to HR. And he told HR what had transpired. And he told both the HR manager and the HR assistant. These individuals were not interviewed by the investigator. When Mr. Barnes reported the April 23, 2021 incident to HR, he asked them to place him under the supervision of another manager. He'd never had any issues with multiple other supervisors that he'd worked for in the past. And at that time, he also told HR about his mental health diagnoses and explained how they affected him. Even went so far to pull up his VA benefits page on HR's computer to show them. He asked HR if they wanted additional documentation from his providers and was told that they didn't. He requested an accommodation to continue in the same position that he had, but under a different supervisor. He was told to write up this request, and he did that and sent it to HR by email. In that email, he also provided examples of his manager's unreasonable, vague, and angry demands. He was assured by HR that they would look into it beginning that same day. And in the meantime, over the next 5 months, Mr. Barnes continued in that position under the same manager. But he didn't hear anything. He didn't hear anything until July 29th, 2021, 5 months later. And before that, whenever he inquired of human resources, he was told, we're looking into it. When he went to the July 29 meeting, it was his supervisor and the HR manager. And at that time, he was given two options. He was told he could be demoted to the position that he held when he was first employed by Hubert in 2006, a shift electrician working days, nights, and weekends at a reduced rate of pay and increased hours, including 12 hours of mandatory overtime, or he could resign and receive 3 months severance pay. Mr. Barnes offered to provide them with a doctor's note to explain why he could not do the shift work due to his mental health, and they declined to accept one. They attempted to paint the shift work as an option that was not a demotion, but he could earn more with the overtime. As an employee of Huber, Mr. Barnes was entitled to protections afforded by the Maine Human Rights Act. He requested a reasonable accommodation for his disability. He used those terms by email on July 28th, the day before he was terminated, to HR or to the corporate office. And at that time, he did request to work under another manager. But what didn't happen is he was never involved in any interactive process to see if something could be done that was reasonable. Huber's position is that while working, your request for an accommodation to work under another manager is unreasonable. And the only other option is a shift electrician. But they didn't involve Mr. Barnes in an interactive process to see what else might be able to be done. There were 5 months that this went on. 5 months that they could have been working with Mr. Barnes to collaborate and come up with a solution. Perhaps send the manager to sensitivity training and have an HR manager present during their meetings to make sure that they went smoothly and the meetings were not confrontational. To try to do something to rectify the situation, but that wasn't done. He was shut out of his meeting, out of any meetings concerning the issues until his termination. He was given a take it or leave it option. There was no process for them to collaborate together. Take it or leave it. You can resign with 3 months pay, we'll terminate you, or you can be demoted. Mr. Barnes respectfully requests that the Maine Human Rights Commission find reasonable grounds exist to believe that unlawful discrimination did occur. We rest on the remaining arguments set forth in our disagreement with the investigator's report and reserve any remaining time. Thank you.
Thank you, Attorney Swanson. Questions from commissioners for Attorney Swanson? Commissioner David.
Attorney Swanson, you're saying that the reasonable accommodation is to change supervisors? That's an accommodation for his disability?
That was the accommodation specifically requested by Mr. Barnes. Yes.
You don't mention the PIP evaluations, personnel improvement plan. Were those justified? Or do you argue that they're unjustified because of this disability? How do they fit in your analysis?
We would argue that the PIP plans were not justified. Those PIP plans were essentially based on these communications issues by Mr. Barnes, by a manager who he had not worked under before. The PIP plan did not come into place until there was this new manager with a different management style that Mr. Barnes had difficulty with. And the PIP plan required multiple meetings, but these PIP plans were very vague. They asked Mr. Barnes to do things that were vague, and when Mr. Barnes thought that he was doing them, he wasn't given a clear explanation as to what he'd been doing that was not satisfactory to the manager, he'd be told, well, I'll get with you. I'll get with you and we'll talk about it. Or you need to communicate better.
Well, the investigator found that the PIP plan referred to his inability to do the leadership functions that were necessary for the job. And they also found that complainant blew off the plan. Did he complain about the plan? Did he interact about the plan as being inappropriate?
Yes, he did. And he didn't blow off the plan. I would also point out that this plan was developed by the very supervisor who he was having difficulty with, who he explains that he had these communication difficulties with. And when he'd go to meet with him about these things, he was berated, belittled, yelled at, and essentially shut down. He did not blow off the plan. He would attend meetings with the manager. He put everything into a system so that the manager could see everything that he was doing. So we disagreed that he was not compliant with the plan.
Thank you.
Any other commissioner questions for Attorney Swanson at this time? Being none, you'll have about 2.25 minutes when we come back to you. And then I believe Attorney Strader, are you representing both respondents?
Yes, I am.
Okay, 10 minutes.
Thank you. Good morning, commissioners. My name is Dan Strader, and as I said, I represent the respondents, Huber Engineered Woods. We don't have a lot to add to Investigator Leva's report. We agree that the investigator got essentially all the material points right, both on the facts and the law. I want to address a few things that were just said by Attorney Swanson and go through some of the highlights of the report. But Investigator Leva correctly concluded, first of all, that no accommodation request was made by Mr. Barnes in the context of his February 2021 PIP meeting. He was placed on the PIP and demoted at that meeting before he uttered a word about his disability. Even when he mentioned that he had a disability, it was perceived by I won't say the name, by his supervisor as really a way to try to explain or just let him know, hey, I have difficulty communicating. Mr. Barnes did not request that his supervisor do anything, as Investigator Leva found, and she was correct. And even complainant's response to that is, well, he didn't maybe say it, but he hoped that his supervisor would change his management style or sort of do something differently. But that's just not the law. The law does not require the supervisor or the company to guess at what an employee might need simply because they let it be known that they have a disability. And it's really undisputed that Mr. Barnes did not request the supervisor to do anything. Investigator Leva also correctly found that Mr. Barnes essentially did not comply with his performance improvement plan. He skipped multiple meetings. And he makes excuses for that. He says, well, the meetings being on Monday, that wasn't a good day. It should have been a different day of the week. He says that, well, when I came to these meetings, Investigator Leva found he was unprepared at these meetings. I think that's an accurate characterization. He says, well, I wasn't unprepared, that in fact, there was information on some shared computer drive that my supervisor could have dug out some documents and seen what I was doing. But it's a perfectly reasonable expectation of any PIP to say, we're going to meet regularly, and I need you, the employee who's on the PIP, to explain to me, the supervisor, what it is you're doing, how are you making progress towards these goals. So by not coming to the meetings and then coming to the meetings occasionally with no notes prepared, no sort of update to share, and just saying, well, you could look at this computer drive and you can figure it out on your own. That's on its face, that's not complying with the PIP. So I think it's hard for them to argue that in fact there was not justification for the employer's decision that Mr. Barnes was not meeting performance expectations, or that somehow those performance expectations were unreasonable. It is true that in late April 2021, Mr. Barnes disclosed to HR that he had a disability. Before he made that disclosure, he sent a lengthy email that is in the record, in which he said, essentially, my supervisor is a bad guy to work with. We don't get along. He's mean to me. He's bullying me. doesn't say a word about a disability in that email. He says, I want a new supervisor. He then goes to meet with HR. He says, I have this disability. Again, makes no attempt to tie the request for the new supervisor to the disability, did not explain how the new supervisor would impact his disability or support his ability to meet performance expectations. Mr. Swanson points out, and as Mr. Barnes had said, that while I worked better with other supervisors in the past, that may be true. He wasn't doing the same job. So we don't dispute that he was a good performer as an electrician in some of the other jobs he'd had at the plant over time. In fact, that's why he was offered an electrician position sort of in the final meeting. He did perform well in a different role with different supervisors. He was not performing well at the reliability job, which required both leadership responsibilities and sort of longer term planning, mapping out maintenance goals and reliability goals for the plant. And he just wasn't doing that part of the job. Small distinction, but I can't let it go uncorrected. I think council just said a few times that there was a 5-month gap between this meeting and the final meeting. It was actually a 3-month gap from late April to late July. The fact that there was not more interactive discussion of his request to move to another supervisor, I think is actually evidence that supports it was not understood by anybody at Huber that Mr. Barnes was in fact requesting a reasonable accommodation. He was just saying, I'm not performing well for this supervisor. Can you give me a different supervisor? And I think that will solve all the problems. That request was considered. Again, it was not being considered as a reasonable accommodation request at all by Huber. They were not understanding it in that light as he didn't communicate it in that light. And so there really was no grounds to have further interactive dialogue. Had that happened, and I would say that at the meetings, there was 2 meetings where this shift electrician option was discussed. At that time, Mr. Barnes made no attempt to say, well, how about this? How about something else? And it is incumbent on him to, come up with some ideas. He says, I want a supervisor. We say, we can't do that, but we'll give you a different position. If he thinks that's not good enough, he can then come up with, well, how about this? And this option that he says, well, maybe there could have been some sensitivity training or something for his supervisor, or HR could get involved in these meetings. Even assuming that would be reasonable, and I'm not sure it would be, he never suggested that. And frankly, he didn't even suggest that at any point in the complaint process until right now. This is the first time I think I've heard that suggestion. As I'm sure you all know, the law is really clear. Even if arguably he requested an accommodation in this late April meeting, which I don't think he did, and even if there was some obligation to do an interactive dialogue, he still must show that there was a reasonable accommodation that interactive dialogue could have uncovered that would have met his needs. There's no evidence to show that had he just had let's say a gentler, nicer supervisor, that would have allowed him to meet expectations as a reliability engineer, because he wasn't meeting those expectations for 2 years. And they weren't really directly tied to the communication, the long range planning and other things that he wasn't doing. There's no evidence to suggest that would have changed under a different supervisor. I think what he was really hoping for is to get out of a performance management process by going to a different supervisor who might have a different opinion of his performance, but that's not a reasonable accommodation. The report also correctly cited, there's case law, there's also EEOC guidance that says, as a matter of law, changing supervisors is just not a reasonable accommodation, particularly under these kinds of circumstances where there's a performance management process already underway. And to the extent that the shift electrician position would not have been feasible for Mr. Barnes to accept, I mean, he does talk about in his complaint that that would have exacerbated his PTSD, his anxiety. That may be true. But what that would mean is that there was no reasonable accommodation that existed. It doesn't mean that all of a sudden changing someone to a different supervisor in a different department that's not part of maintenance, that isn't really appropriate for this reliability position, that somehow transforms that into a reasonable accommodation. Sometimes the unfortunate fact is there just isn't a reasonable accommodation that exists in a given workplace for a given job that can adequately accommodate somebody's disability. And that happens. And that may be what happened here. If in fact he couldn't do the electrician shift position. So There's, I think Investigator Leva correctly concluded that were no reasonable grounds to find that Huber failed to accommodate or acted in a discriminatory manner towards Mr. Barnes. I'll leave it at that and certainly answer any questions the commissioners may have.
Thank you. Any commissioner questions for Attorney Strader? Seeing none. You'll have about a minute and a quarter left when we come back to you. Attorney Swanson, you have about 2.25 minutes.
Mr. Barnes was demoted in February of 2021, but that was by title only, not by pay and not by benefits, but by title only. And Mr. Barnes wouldn't skip meetings and try to justify them. These were on Mondays, and after returning from the weekend up, sometimes there was equipment down. Mr. Barnes had been there for a very long time, and he knew what it cost the company when equipment was down. And he would try to communicate with his manager and say, we'll get together after I fix the equipment, but that wasn't good enough. And he didn't expect his manager to just log into the computer and figure it out himself. He would do that with the manager if the manager were willing to listen and do it, but the manager didn't want to meet with Mr. Barnes. The manager wanted him to put everything into a PowerPoint and let him review the PowerPoint instead of meeting with him. And this was taken away from time when Mr. Barnes had other duties and responsibilities. Mr. Barnes had done the same job under prior supervisors as the reliability engineer for about 2 years before his current manager. And the respondent indicates that it's incumbent on Mr. Barnes to come up with a solution here. Mr. Barnes made a proposal, and he used the words reasonable accommodation to corporate before he had the ultimatum meeting. The meeting wasn't, let's talk about this and see if there's something we can do. It was with HR and this manager who he had been having difficulty with saying, take it or leave it, Thomas. That's not interactive. It was incumbent on the employer to work with Mr. Barnes to try to figure this out. And that's not what happened. They had plenty of time to do it, and they didn't. They let him continue in the role for 3 months, 5 months, however long it was, and then they gave him an ultimatum.
Thank you, Mr. Swanson. Any commissioner questions for Attorney Swanson? Not seeing any. Commissioners, if you look like you're thinking about it. Nope. Okay. Thank you, Mr. Swanson. Attorney Strader, you have about a minute to order.
Thank you. Briefly, I think this is obvious, but just to point out the law offering a demotional position when no lateral reassignment position is available and there's no evidence that there was a lateral reassignment available, that is not unlawful. A demotion is certainly a reasonable accommodation that can be offered. I hear a lot of disagreement with the performance opinions or priorities of Mr. Barnes' supervisors. You know, Mr. Barnes didn't think Mondays were a good day. Mr. Barnes didn't think that the supervisor's opinion was correct. But that really doesn't justify him saying, you know, well, I just don't need to follow this, or, you know, I can later say, well, he was just wrong. You know, there's no evidence that the supervisor's opinion was in any way tainted by disability animus or anything of that nature. I don't think that's been suggested. Mr. Barnes simply had a difference of opinion, and he's entitled to that, but that doesn't mean that the supervisor was acting unlawfully by enforcing his performance expectations. And in terms of the reasonable accommodation, I just want to be very clear. The email that's being discussed as the first time that Mr. Barnes used the word reasonable accommodation was the day before the final meeting, 2 days after he'd already been presented these options, and they'd been allowed to discuss those and consider those, hadn't proposed anything different. Even in this other email, he suggests nothing new. He just continues to say, I want a new supervisor. So again, had he come up with some other proposal that he thought was a better
Schrader.
proposal than the shift electrician, maybe
Mr.
that could
Schrader.
be considered. Thank you.
Yes, thank you. Any commissioner questions for Attorney Straden? Seeing none, thank you. We're going to turn to the investigator. This is the first time the commissioners are hearing from our newest investigator, Nupur Leva. I probably pronounced it wrong because we always just call her Nupur. So, Nupur.
Thank you.
Nupur.
Thank you, Amy, and you did get it right, so no worries. Commissioners, good morning. I don't really have very much to add to my report and what my analysis was and how I got to my decision. Attorney Swanson did mention that there were a couple employees that I didn't interview. I attempted to interview them. Neither one were still with the respondent, and therefore I was unable to do so. And I, again, just focused on what the accommodation was, what was asked, and whether or not it was reasonable. And in this case, it, to me, the final analysis didn't feel like a reasonable accommodation.
Any commissioner questions for the investigator? Seeing none. Great job, Nupur. Thank you. So commissioners, you've heard from the parties and the investigator. There is one proposed finding that we'd be looking for a motion on. Commissioner O'Brien.
I move there are no reasonable grounds to believe that Huber Engineered Woods LLC and Huber Engineered Woods LLC. Discriminated against complainant on the basis of disability, reasonable accommodations, discharge, and the complaint be dismissed.
Second.
Well, it's been moved and seconded to find no reasonable grounds. Is there any discussion among commissioners? Mr. Davis.
Thank you for the report, Nupur. I think it's excellent. I agree with the conclusion. It doesn't seem to me to be reasonably related to his disability for him to just say, I want a new supervisor. And that essentially is his consistent position. And I don't think he's shown any discriminatory animus that that it's pretextual. There are clearly performance issues, and he's not dealing with them. And I guess he's saying that he can't deal with them, but that's unclear. But there's not discrimination based on that disability.
Any other discussion among commissioners? Seeing none. The motion is to find no reasonable grounds to believe that disability discrimination occurred. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
So since Commissioner Ashby is recused, that's a finding of no reasonable grounds, and the commission will send parties and council a letter confirming that, and we thank you for your participation today.
Thank you.
All right. Next on our agenda is case number E21-0518 A, B, and C. It's Catherine Stinson versus Aspen Dental Management Inc. Oaks LLC and Juno Dental LLC. This is a no reasonable ground case we'll hear from. Looks like the complainant's rep.
Yes, I'm going to try to do this properly.
I'm going to use my own this time as well.
Okay, let's see what happens. Yep, did it.
Well, good morning again, commissioners. I appear before you this time to represent Kate Stinson, who is sitting behind me. I appreciate the opportunity to explain in more detail why the investigators recommended no grounds findings are legally and factually flawed, such that reasonable grounds filings are warranted. Set forth in our written statement detailing points of disagreement with the investigator's report, Ms. Stinson provided more than ample evidence to establish at least an even chance that she'll be able to prevail on each of the elements required to establish sex and disability discrimination, as well as whistleblower retaliation. Now, she worked at 2 different Aspen Dental branded offices, one in Portland and one in South Portland, which she was involuntarily transferred to after she took a medical leave. I'd be happy to expand or speak on any topic that commissioners would find helpful, but I wanted to focus my remarks on 3 separate issues. First, the report concludes in just a footnote that there's not sufficient information in the record to conclude that the 2 practices, which are separate legal entities, were a single employer. As detailed on page 2 of our submission, and this is the case that I referenced earlier in my remarks, the idea that respondents have to be a single employer in order for liability to attach is contrary to settled law. The question is whether respondents are Kate's joint employer, a legal concept that acknowledges the reality that operations of technically separate legal entities can be intertwined such that liability attaches to more than one entity. The factors that are assessed for that inquiry include common ownership, common management, interrelated operations, and centralized control of labor. Here, Kate worked for 2 separate Aspen Dental branches in Portland and South Portland, and they were owned by the same person, who I will call Dr. O. Dr. O also has a partner at the South Portland branch, a Dr. U, but the record is actually replete with information showing that these Aspen Dental locations operate as one joint employer. Aspen Dental HR supports personnel. Both practices use Aspen Dental employee handbooks, Aspen Dental letterhead. They use Aspen Dental email addresses. They share Aspen Dental employees, not just including Kate, but many others, including one employee who we filed a statement from her. She actually works in all 10 different Aspen Dental locations in Maine. They aren't hired, as with the previous case, they're transferred. And on this record to say there's just not sufficient information to show that respondents operate as joint employers, I would argue is clear error. It's also contrary to what the commissioners found earlier today in a separate case. Second, the report states in a conclusory fashion again in a footnote that she provided no facts alleging disability discrimination, none. It states that Kate did not even allege that she experienced an adverse employment action on the basis of her disability. Perhaps this footnote was intended in a separate case, but there are actually facts that are in the record that would support disability discrimination. Kate is a person with a disability and was given a reduced schedule when she returned from FMLA leave as an accommodation for her disability. During this time period, Oaks LLC, that's the branch that she was transferred to involuntarily in South Portland, admitted that she wasn't given a raise she requested because in part she was working part-time and the other employee who got one, a male, was working full-time. The only reason she was working part-time is that she was being accommodated for her disability. So that's not just simply a fact, that is direct evidence of disability discrimination and an adverse employment action being taken against Kate because she had a disability. Third, the report concludes that there's no direct evidence of sex discrimination. What the report missed is that just before she resigned, she received a performance feedback notice, which is commonly referred to as a PIP, that included as an expectation going forward that she was to have, quote, no more temper tantrums, end quote. This language was used with a professional woman that has more than a decade of experience as a dental hygienist, an adult woman. It is respectfully stated that the phrase temper tantrum would never be used to describe conduct that a middle-aged man would engage in their chosen profession, even if they disagreed with a colleague, even vehemently. Pointedly, respondents never provided any evidence to suggest that men were ever accused of having temper tantrums when they disagreed with their colleagues. Direct evidence of sex discrimination includes employers' use of words like this that imply inequitable and pejorative expectations for women. And I would respectfully ask that the commission take the opportunity to correct the report insofar as it says there's no evidence of sex discrimination. As that comment, again, I would say is direct evidence that there are different expectations for women and men from the Aspen Dental branches. Thank you.
Any commissioner questions for Attorney Dietrich? I'm using my time. I trust my time. Things too now. Any commissioner questions for having me? Yes.
Yeah, I think that one of the allegations was that she disagreed in front of patients with the dentist's diagnosis or diagnosis of not having periodontal disease present. Can you address the appropriateness of that?
Sure. Part of Kate's job duties was perform periodontal examinations. And that examination to her suggested one outcome and to a dentist suggested another outcome. There is nothing improper about two colleagues having a difference of opinion. The incident that actually precipitated the performance improvement plan was that a Dr. S treated Kate as though she wasn't even in the room when she offered commentary of what she assessed was periodontal disease on a patient. So I think it's really a red herring in this case, the fact that colleagues or even a subordinate and a person who is technically below can have a difference of opinion. That is actually how the process is supposed to work. That's not improper. But I would argue that Aspen Dental's response to that is what is in fact indicative of improper conduct.
I don't think anybody's saying that the difference of opinion is improper. It's in front of the patient that's improper, isn't it?
If it is improper, there is evidence in the record that other employees of Aspen Dental disagreed politely, professionally in front of patients and were not treated in the manner in which Kate was treated, which was really to minimize and demean her.
Okay, that would be significant if that's. And you say that that's there?
It is.
That the differences expressed in front of patients, what, by male hygienists?
There is only one male hygienist that worked at either of those two locations, and it is in the record that he was treated in a more favorable and less judgmental way, even though many female hygienists reported to management that he was committing fraud and improperly conducting examinations. So in essence, you have women doing what they should do and being treated like children, and a man who is performing in a less competent fashion getting a pass.
Additional question? Yes, sure, Brian.
Did you just say that that there were several reports of the male falsifying records? Did I hear you say that?
Yes, Ms. Stinson was one of a few employees that brought to the attention of Aspen Dental that there was a male hygienist falsifying records, two of whom have filed written statements in this case.
Any other commissioner questions for Attorney? Five minutes.
Thank you.
Then we return to respondent, I believe, Attorney Marcus.
Yes.
10 minutes.
Thank you. Good morning, commissioners. My name is Joshua Marcus. I represent the respondents Aspen Dental, Oaks LLC, and Juno LLC in this matter. The arguments raised by complainant do not alter the result. The investigator's decision is well reasoned and it's a detailed report. And complainant focuses a lot on a lot of ancillary issues which really are not germane to the investigator's report or the investigator's no reasonable grounds recommendation. And the investigator got it right, and the report is supported both by law and fact in this matter. Complainant doesn't dispute that she resigned her employment. And she's failed to offer any facts supporting a constructive discharge in this case. Nor does complainant dispute that she walked out of work on the day in question in this matter, and which one was an issue in that she got into an argument with a doctor in front of patients, and two, left midday, abandoning the numerous patients that had already been scheduled, which significantly impacts patient care and client relations, which was a significant issue. And, you know, complainant again focuses on one word, you know, I guess one sentence at the bottom of the performance feedback notice. But the performance feedback notice that she received after this incident clearly states that the reason for why she got it was getting in a verbal disagreement on June 24th, 2021 with the doctor in front of a patient due to not agreeing with his TX plan. And again, the doctor is the one, he is responsible for medical care. While Ms. Stinson can certainly voice her opinion, and no one is saying that she cannot, it is not her medical license on this. This is the dentist's decision. And doing, you know, arguing in front of a patient is not the way to go about it. And then when she ultimately just left that day, and again, the performance plan clearly states leaving in midday on June 24, 2021, because you were angry, patient abandonment. This is all clearly spelled out. The performance feedback notice was also issued by the office manager, who was female. So, you know, this is not a sex discrimination claim. Their disability doesn't play any role into this. There doesn't seem to be any facts that this really was, that there was a dispute on those issues. You know, complainant also argues that she was treated differently from a full-time male hygienist because he got a raise. Again, there was a legitimate business reason for doing so, which was articulated by a respondent, and it's issued in the report. The male hygienist received a raise after receiving an offer from another practice, and Oaks LLC needed to go and get, to retain the male hygienist. Most importantly, which of course complainant's counsel doesn't mention at all, is at the time, Ms. Stinson was already earning more money than the male hygienist. So this is not a male female thing. There was a legitimate reason for this, and complainant has not tied any of this into her disability, gender, or her prior complaints. We do acknowledge that Ms. Stinson and another employee had made complaints regarding the male hygienist, and that he was not inputting. It was articulated as he was not inputting data correctly, or that they were disagreeing with some of his diagnoses. And there was an allegation of falsification, but mostly it was the prior two allegations. And again, the investigator properly concluded that there was a statement from the female director of hygiene who had stated she looked into this and didn't find anything. But again, that had nothing to do with the bottom line fact that complainant had quit her employment, and that there was sufficient reasons, legitimate business reasons, for issuing the performance improvement plan. And finally, complainant spends a lot of time talking about the single employer, but as it's pointed out in the, it's kind of a red herring in this case. One, there's no reasonable ground, so it really doesn't, we don't really need to get into in depth on the single employer issue. But two, on top of that, as referenced in the report, issues relating to complainant's performance at the other practice, Juno LLC, are all time barred. So again, it really does, while it really has nothing to do with this, with this case, and really, again, serves as a red herring. And just to be clear, Aspen is a management company. They do provide some human resource ancillary functions, but they're not making the decisions on any of these things. When there's talks about transferring from one Aspen practice to another, Aspen's a large management company, so that happens. But these decisions are made by the individual doctors who own the practices and who are the LLCs that are named in this matter. So I thank you for your time, and thank you if there's any questions.
Thank you. Any commissioner questions for Attorney Marcus at this time?
Attorney Marcus, would you react to the comment made that she had a temper tantrum? Is that not belittling and an indication of a discrimination that probably wouldn't be made against the male?
Again, respectfully, no. There was a history of Ms. Stinson acting inappropriately with other employees, both at that practice and at Juneau. In fact, calling an office manager the C word and the B word. So there's been a history of her acting up in the office towards other employees, and clearly her reaction in in the disagreement, she's allowed to have a disagreement, to walk out and storm out, while you can argue about the language. It's as set forth in the as it's described in the performance review. That's what we're talking. We're talking about her reaction to that, and that's what's clearly stated for the reasons for why that performance plan was given.
Any other commissioner questions for Attorney Marcus at this time? Seeing none, you'll have about 4.5 minutes when we come back to you. Attorney Dietrich, you have 5 minutes.
Thank you. I want to touch on a few issues that Attorney Marcus brought up, and I just want to make clear, just because I didn't talk about them in my opening remarks doesn't mean that we don't contest them as written in our responsive submission. With respect to the constructive discharge piece, Kate has and does contend that she was constructively discharged. On page 5 of our response, you'll see that we sort of did a little call out of some of the PIP that was given to her. In addition to the temper tantrum language that I referenced earlier, there was also an indication that she was required to have, quote, no more last second call outs. And that is for somebody who has crippling anxiety and is disabled, just not something that you are able to promise or accomplish. She felt like she was being set up to fail. In addition to that, the meeting and the circumstances of that PIP made it clear for her that her time at the company was limited and that she wasn't going to be able to be successful there. I want to loop back to something that Attorney Marcus referenced a few times incorrectly in his remarks. The incident that just preceded the PIP and her resignation was that situation we discussed where she and a doctor disagreed about whether periodontal disease existed. She went to the office manager and was not feeling well and was given permission to leave. She left the office sick with permission, went to go get a COVID test. She was not feeling well. So this idea from respondents that she abandoned patients and left without permission is just incorrect and unsupported by the record. The office manager that still works for respondents, my understanding, could, if she did not already, confirm that she gave permission to Ms. Stinson to leave. So we do dispute that she walked out from work and abandoned patients, as Attorney Marcus said that we didn't. We do. I think everybody agrees that a male hygienist and a female hygienist both asked for a raise. He got one, she didn't. There was some sort of hearsay scuttlebutt that maybe he had another offer, but as the investigator notes in his report, he wasn't able to confirm that fact. Nobody's been able to provide admissible evidence on that fact. So all that we're left with is that a full-time male employee who was brand new to the profession, so of course he got less per hour, than a female hygienist who was working a part-time reduced schedule because of her disability, didn't get one. I'll leave it there and I'm happy to expand on anything else that would be helpful.
Thank you. Any commissioner questions for Attorney Dietrich? Not see it.
Thank you.
Thank you. Attorney Marcus, you have 4.5 minutes left.
Thank you. I'll be very brief. Just on a couple of points that Ms. Stinson raised. Again, going back to the performance improvement plan and feedback notice. Again, it clearly states why the reasons that it was given. It wasn't given about temper tantrums. It was given because of a verbal disagreement that she had with one of the doctors, and because she left midday with patient abandonment. There's nothing in the record reflecting that she was authorized to leave. Notably, she's given the performance feedback notice. There's nothing in the record that she contested that, nothing in writing. That doesn't exist. And then again, onto the issue about the male doctor, again, there's a, the allegation is that the investigator didn't, follow up on this. There was testimony to that fact that the investigator received. That hasn't been refuted by Ms. Stinson. She has that burden. So to sit there and challenge the investigation on that grounds is insufficient. That's it on my points. Thank you.
Commissioner questions for Attorney Marcus?
Good morning. So Attorney Dietrich just made a very interesting point in her last presentation, about the pay raise, right? I mean, so her client is working part-time, a reduced schedule as part of her FMLA intermittent leave, right? And she contends an accommodation for disability. And then she asked for a raise and she's denied a raise because she's part-time. Whereas the male hygienist is not under these constraints. So I'm just curious, what's your response to that? Because I think that of all these arguments here, that's the one that's sort of the most compelling to me in terms of why maybe we should do something different here.
Again, and I think this was addressed in the investigator's report. I mean, twofold. One, you had a situation where you had the male hygienist had received an offer from another job, and this was an effort to make it, to retain that. That had nothing to do with complainant or any basis relating to her gender, or there was a preferential treatment. It was because there was another offer that had come in, and losing a full-time or any person would have been significant. There was, there's no testimony that Ms. Stinson had an alternate offer or anything along those lines. Similarly, again, Ms. Stinson was earning more money at this time. So this is not a situation again where that this is now we're treating someone else better. Ms. Stinson is already at a higher level. She's been accommodated. There's been no allegation from what I've heard at any point that she wasn't accommodated. They went from a longer schedule to 2 days. They allowed her to create her own schedule. A lot was done to accommodate her. And again, this has nothing to do with those accommodation questions. It really becomes a question of, you have the male hygienist who was offered somewhere else. There's no comparable where Ms. Stinson was offered anything else. And on those grounds, again, the male hygienist was still earning less.
I mean, he's earning less, but Ms. Stinson is more experienced and more qualified, true?
Well, Ms. Stinson, it was there longer. There's that we're not going to contest.
Okay. All right, thank you.
Any other commissioner questions for Attorney Marcus? Seeing none, thank you. Then we would turn to the investigator, to Colin Hurd.
Hi, good morning, commissioners. As you know, my name is Colin. I was the investigator assigned to this case. A few things I'd like to bring up. First of all, the permission piece that was just mentioned there at the end. I don't recall that being in the record, and I may have missed it. That she got permission to leave the day of the altercation with the dentist. From my perspective, how it appeared to me was that they had the disagreement. There was an argument, and then she left. Maybe the COVID thing came later, but that's what I recall from the record. A few other things. So regarding the joint employer issue, I'm perfectly willing to concede that I didn't get that piece right, but I think as far as whether they should be a single entity or a joint employer or not. However, even if we do accept them as a joint employer, I don't think it really changes my analysis in this case. The events which occurred at Juneau, the first place that she was at, were all before the 300-day jurisdictional deadline that the commission has. And the things that were after that deadline didn't begin until she returned from her medical leave and started up at Oaks. Furthermore, what happened at Juneau and at Oaks were not contiguous with one another, at least from my perspective. Complainant had claimed that Juno was not following its COVID cleanliness policies. And Juno claimed that it was, and the disagreement culminated in an argument where a complainant left work in the middle of the day, and then right after that, she went on FMLA. So from my perspective, there was no adverse action that had occurred from Juno's perspective, and she was transferred shortly after that. I think complainant might be arguing that the transfer itself was an adverse action. She mentioned several times that it was, I can't think of the phrase, but she didn't request it. It was a quote unquote forced transfer. But it was hard for me to see that as an adverse action. For one, it wasn't materially adverse to her. It removed her from, well, it was, I guess it was only 10 minutes away. I Google mapped it. It was only 10 minutes driving distance between the two. And honestly, it removed her from a tense situation and put her in a new situation where she might be more successful. I think that was the argument that respondents made, and that made sense to me. Regarding her time at Oaks, there was definitely some conflicts, personality conflicts with the male hygienist there, not just with complainant, but with the other witnesses, female witnesses that were mentioned by complainant today. And I have their statements. But after reading those statements, there was no description in those statements that rose to the level of illegal harassment or a hostile environment. Certainly, he was, from my perspective, looking in from the outside, he didn't seem like a great employee. He did a lot of things that I can understand other employees being frustrated with, whether male or female. For example, I think he would shirk his cleaning duties and play on his phone in the doctor's office and things like that. He raised his voice a few times to some of the other employees. Obviously, those are problematic things for another reason, but they didn't seem discriminatory or harassing to me. Also, yes, in addition to complainant reporting that they believed that the person characterized as male in the report was falsifying records, I think that Oaks took appropriate action because the person labeled as director, and I can't remember her full title at this moment, but she's called director in the report. She investigated those claims, and she came to a determination that she didn't believe he was falsifying records. And even if the complainant and the witnesses didn't agree with that, I think it's still the appropriate action for the respondents to take in that situation. Regarding the situation of the raise, where the male hygienist received a raise and the complainant did not, some of this has already been brought up by Attorney Marcus, but just to reiterate it from the way I was looking at it. So complainant's submission of disagreement focused a lot on the fact that I wasn't able to confirm whether the male hygienist had indeed applied for another job, and that the raise was given in order to keep him. I think that was just part of the reason. That was definitely a reason why they wanted to give him a raise, because they were afraid of losing employees for COVID and all that. But what seemed to me the most compelling reason, which was probably the primary reason, which was also given by Oaks' owner, which was that this issue of her working part-time and him being full-time. So if she had gotten the raise, her as a part-time employee, she would be making more money on a weekly or whatever basis than the full-time employees were making. So the combination of those things together, Oaks owner said he didn't feel like it was fair to give her a raise at that time. I think that part of the accommodation was that she wasn't always going to be on part-time. It was a temporary thing, and she was coming back to full-time. And I think that if she had been at full-time, or it would have been more likely that she would have gotten the raise at that time. That's obviously speculation on my part, but I agree with and I believed the reason that respondent gave me in that situation. Let's see, not last but not least. The complainant stated that because she was part-time as a reasonable accommodation, that the fact that she didn't get a raise because she was part-time is an example of disability discrimination. Personally, I disagree with that characterization, but obviously it's up to the commission to decide whether those things are proximate enough to imply discrimination. I don't think that her sex or her disability necessarily came into the calculus for that. And then, so now, last but not least, I wanted to address this phrase in the PIP about temper tantrums. The complainant's arguing that that was a sexist phrase, and while the phrase is certainly inappropriate, I again personally disagreed when I read it. I didn't even think of it as being sexist, but I disagree that it is sexist. Put it in context. It's referring to a specific incident in which she left the dental branch in the middle of the day after arguing with the dentist over the diagnosis. That's how I took it. But also, I've personally witnessed many adult males in my life have temper tantrums. And I've heard those incidents described as temper tantrums. So I think the term is gender neutral. And at the time that I was reviewing the record and writing the report, I didn't view it that way. That's all I have to say, and I'm happy to answer any questions you have.
Thank you, Commissioner David.
Colin, I think you started out by saying you might have gotten it wrong about the two entities. I'm struck by footnotes 1 and footnotes 2 at the very beginning of the report. Footnote 1 says, do you agree that we shouldn't be asked to make a finding against both entities? Or do you just think it doesn't matter because the recommendation is that there's no reasonable grounds?
I would lean towards the latter. I think that, I mean, I don't have the power to just dismiss Juno because that I, you know, as a respondent from this case, but I think that the things that happened at Juno were separate and before the 300-day deadline. So yeah, I didn't analyze them in this report. I don't know if I'm answering your question or not.
Well, I guess I need to ask. No, I guess, no, I don't. This footnote 2 says disability discrimination will not be analyzed further. And yet we seem to be talking about whether there's disability discrimination.
Right. So there was no allegation made specifically during the investigation that because of my disability, well, except for the fact that it's checked off on the complaint, there were no facts given during the investigation that implied that any decisions or adverse actions that were taken were based on complainant's disability itself. She was diagnosed with, I think it was major depressive disorder and anxiety during the FMLA. So that was actually after her period with Juno. She was diagnosed during that period right before she started at Oaks. There was plenty of evidence, and we've talked about it in the record, that she got all the reasonable accommodations she asked for. And then, you know, at the end of it, except until this point where we're talking about the part-time status as an RA, it was never brought up that the termination, or actually it wasn't a termination, her resignation and alleged constructive discharge was related to her disability.
Right,
sorry,
so
that was very convoluted, but it makes sense.
No, your analysis concludes that there's no reasonable ground to believe that there was sex discrimination, correct?
Yes.
All right.
Yes. Right. And then, so I think to answer your question, just the reason that the reasonable grounds or the disability piece is not included at the end there is because I didn't feel there was sufficient facts alleged during the investigation to warrant a full analysis of it.
Right. I guess I have a question for counsel. I mean, I'm if that first footnote says that Juno's claims against Juno are time barred, then they're time barred. Why are they in the conclusion?
As they were alleged, so y'all need to make a finding.
Oh, okay, all right. Good enough. Good enough. I'm comfortable with that.
Any other commissioner questions for the investigator? Seeing none. Thank you, Colin.
Thank you.
So commissioners, you've heard from the parties and the investigator, and at this point, we would be looking for a motion or motions.
Okay, I would move there are no reasonable grounds to, I'll take it together. No reasonable grounds to believe that respondents Aspen Dental Management, Oaks LLC, and Juno General LLC discriminated against Captain Stinson on the basis of sex or disability or interfered with the right to be free from such discrimination, and that there are no reasonable grounds to believe that Aspen Dental Oaks LLC and Juno Dental LLC retaliated against Catherine Stinson for engaging in MHRA or WPA protected activity or interfered with her right to be free from such retaliation, and the complaint should be dismissed.
Second.
So it's been moved and seconded to find no reasonable grounds on all claims presented. Is there any discussion among commissioners?
I could have said it like that.
You could have. Easier way to present it is to adopt those recommended findings. Thanks. Yep. Any discussion?
Now he tells me.
Yeah, I know. You did such a good job.
Thanks.
Very thorough.
Very briefly, I wrestled, I think, with what Ed was wrestling, Commissioner David, sorry. I appreciate council's education, at least of me, on the issue of joint employer. I think if it were relevant, I think I'd be inclined to make a finding that they are joint employers. And I think then that we do get into a discussion of whether or not claims raised regarding the previous employer or time bar. And I think the investigator in his comments about that issue and willing to concede perhaps that he was wrong on the joint employer issue, still then went into an analysis of whether there was a continuum of activity. And I thought that was really helpful. I thought you gave a very good presentation, which I think answers some questions. I was going to ask questions about allegations that were raised at the previous employer and whether or not there was a continuum, and then we'd have this discussion about the 300 days. That's really what I wrestled with most in this. But at the end of the day, I agree with your overall conclusions in your investigation, in that there are no reasonable grounds on both the discrimination and on the gender claims and on the WPA protected activity claim as well. But I thought it was a very interesting case, and I think you did a really good job in both investigating, but then your comments in explaining them. And I appreciate, as I said, I appreciate council's approach as well. I think I look at these joint employer cases different after today.
Any other discussion among you? Seeing none. So there is a proposed finding is no reasonable grounds on disability based on sex. Sorry, discrimination based on sex or disability or interference with the right to be free of discrimination, and retaliation for MHRA or WPA. If you're in agreement with that, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
So the findings are on no reasonable grounds, and the commission will send parties and council a letter confirming that. We appreciate the parties and attorneys' presentations here today. And that is it for our morning hearing agenda, with 10 big minutes before we start the afternoon agenda. If we stretch it, let's keep that for 10 minutes. Good job.
Hello? Hello?
I haven't been undirected in 30 years, so it's gonna be exciting. We'll see. Oh. Yep.
Oh, yes.
Uh-huh, no, yep,
We only have 2 cases. left.
we do, only 2 cases. Because Tom, I think you got here just after I said that the second case on the afternoon agenda has been tabled.
Sweet.
Again.
Are we off mute?
No. Yes, we're ready to go. Oh, great. Okay, you keep doing your thing.
All right, well, the remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. Commissioners have received and reviewed investigative reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. Time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes total may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. And we'll ask that you introduce yourself as you come to the podium or our recognized zone.
And
Thank you.
before we call the first case, I would just remind all people who are presenting at the hearing not to use the names of any third parties. The only names that can be used are entities or individuals who are named as parties in a case. If you are referring to someone otherwise, a witness or a person involved, we have given them a pseudonym in our report, so please use that.
The first case of our afternoon session is EDPA 22-0175. That's Christine Yu versus Sam Critchlow. Forgive me if I mispronounced your name. I'm so sorry. That is a no reasonable grounds case. And as a result, we'll hear from the complainant or their representative.
I believe Ms. Yu is here. Ms. Yu, would you mind? There you go. You unmuted yourself. So you have 10 minutes to present.
Okay, should we show our face or we don't have to?
You can if you want to. The other people involved are on camera, so that's really up to you.
Okay.
So go ahead.
Here I am, Christine Yu. Okay.
Yes, you have 10 minutes.
Thank you. I disagree with the key findings and the decision of the investigator's report. At the onset, it must be acknowledged on review that the entire report is fundamentally inconsistent. It should be reversed on that basis alone. This inconsistency yields a report that undermines its findings because it reveals a basic confusion of the investigator with respect to who, in fact, is the subject of the investigation. The reports start in the first section, number 1, summary of the case, and stated that the complainants complains alleging the respondents discriminated against the son with a notes. While the complainant did not specifically state that this complaint was filed on behalf of her minor child, it is presumed here that she intended to do so, since she did not allege any discriminatory adverse actions taken against her, bracket, as opposed to alleged actions experienced by son. Because of her own protected class status of her or her association with son. Then the report states by the end in the last section 4 recommendation, number 1, there are no reasonable grounds to believe that respondent discriminated against the complainants, which is me, on the basis of ancestry, national origin, race, or disability, or engage in unlawful retaliation for engaging in MHRC protected activity. The investigator's report is internally contradictory, and therefore it should be overturned. Further, with the initial inquiry form sent to me by MHRC on May 4th, 2022, the first question to me was, number 1, would you like to file your complaint on behalf of your son and yourself, or just on behalf of your son? My response in writing to MHRC on May 23rd, 2022 was, my son is a minor, therefore I'm speaking on his behalf. However, we are both victims, and I strongly feel the racism discrimination have been towards my son and myself. Nevertheless, the report limits itself to a finding that me was not discriminated against. Although I strongly disagree because I was a witness to blatantly, unlawfully comments based on my race and national origin. It remains that the effects on my son were not adequately considered. As demonstrated by the concluding language of the report, which applies the findings only to discrimination against the mother, which is me, for foregoing reasons alone, I urge the decision to be overturned. Second, I want to repeat the disagreement I indicated in response to the MHRC investigators' report and decision. I'm sure everyone has my disagreement on hand. If you have not, please let me know, because I think it's very important for you to look at the report's decision and especially look at where I disagreed with. I was evidently racist against by the respondent and his incited subordinate English department chair, but the report blindly concludes there are no reasonable grounds to believe that the respondent discriminated against me. Further, my complaint clearly listed facts of hostile environment, retaliation, and discrimination against my son by the respondent, but the report again blindly ignored or misled all of the evidence that I established in my complaints. Again, for above mentioned reasons, I urge that the decision be overturned. Finally, I find the whole report to be inaccurate, misleading, biased, unfair, and mispresented. It is obvious that the investigator took the respondent's side throughout the report, and that it failed to demonstrate any fair consideration of the allegations made by the complainant. To me, this report seems to be perpetuation of the system of racism that I've experienced. The investigator plainly demonstrates a one-side approach to every single allegation and issue presented in this case. If this report is sustained, I will pursue an appeal for the reasons I've cited. Thank you.
Thank you. Any commissioner questions for Christine Yu at this time? Not seeing any. You'll have about 4.5 minutes when we come back to you after we hear from the respondent. I'm going to mute you in the meantime. And then we turn to, I believe Ms. Morrill is here for respondents.
Yes, thank you. Good afternoon, commissioners. My name is Kelly Morrill, Assistant Attorney General, and I represent the respondent, Sam Critchlow, in this matter. Mr. Critchlow was the executive director of the Maine School of Science and Mathematics during the time period covered by this complaint. Mr. Critchlow agrees with the investigators' proposed findings in this case. And I just want to point out with respect to Ms. Yu's argument that the report doesn't address discrimination against her, the complaint that was filed in this matter contained allegations of discrimination against her son, and Ms. Yu has not pointed out any adverse actions against her with respect to a discrimination claim. So I'm going to address the allegations with respect to discrimination and retaliation against her son. So MSSM is a public residential magnet school. Students are expected to live on campus and attend classes in person. As a result of the pandemic, MSSM was forced to conduct classes remotely during the 2021 academic year. And while he was attending classes remotely in the spring of 2021, this claimant's son participated on his hometown high school's tennis team. At the start of the academic year 2021-2022, all students were expected to live on campus and attend classes in person, and the complainant's son did so up until late March of 2022. On March 26th, the complainant advised that her son had tested positive for COVID-19 that weekend and needed to stay home. As a result, MSSM allowed the complainant's son to participate in classes remotely pending receipt of additional medical information. Shortly after March 26th, however, MSSM learned that the complainant's son had been playing tennis with his hometown high school's tennis team since March 30th. From then on, MSSM continued to attempt to get additional medical information from the complainant to support her son's absence from school and to get an explanation for why he was well enough to play tennis, but not well enough to attend school in person. Despite the lack of medical information, the complainant's son was allowed to continue to attend classes remotely. It wasn't until late April that the complainant provided a medical note describing symptoms that her son was having with no diagnosis. The school's nurse spoke with the son's doctor, who indicated that she was not aware the son had even had COVID, and that might have changed her diagnosis or treatment of him. The doctor also indicated to the school nurse that although the complainant had pushed for remote learning for her son, the son could in fact attend school in person. So as a result, the school developed an individualized health plan for the complainant's son in early May to enable him to return to school. The complainant approved that plan with minor modifications. Ultimately, the son did return to school and take his final exams. So the complainant alleges that Mr. Critchlow discriminated against her son on the basis of disability, race, and national origin. First, Investigator Morse correctly noted in her report that it's unclear whether the complainant's son actually had a qualifying disability under the Maine Human Rights Act. He was diagnosed in mid-May with a fairly common medical condition that could have been managed on campus. In any event, Mr. Critchlow and the school acted in good faith and allowed the complainant's son to participate in classes remotely until it was time for finals. Second, there's absolutely no evidence in the record of discriminatory animus or that the complainant's son was excluded or treated any differently than other students based on his race, ancestry, or national origin. Respondents submitted many emails containing discussions between the complainant and Mr. Critchlow regarding the son's situation. Those emails reflect that the school had legitimate concerns about why the complainant's son was unable to return to campus and attend classes in person. The school was receiving conflicting information from the complainant and the hometown high school and was not receiving adequate medical documentation to support his continued absence. It appears from the email exchanges in the record that at least one of the reasons why the complainant's son wanted to remain at home was so he could play for the hometown school's tennis team. In fact, there's an email in the record that reflects that the complainant's son told the hometown high school on March 8th that he would be back home by March 19th in time to start the tennis season. That communication occurred almost 3 weeks before the complainant told MSSM that her son needed to stay home because he had just tested positive for COVID. Third, there's no evidence that any material adverse action was taken against the complainant or her son in retaliation for asking for an accommodation. The record reflects that Mr. Critchlow and the school acted in good faith and tried to work with the complainant and her son to ensure that he successfully finished the school year. The complainant has failed to provide any evidence of discrimination or retaliation here, but instead has provided only unsupported, speculative, and conclusory statements about Mr. Critchlow's motives. We ask that the commission adopt the investigator's recommended findings of no reasonable grounds on all claims. And I'm happy to answer any questions the commission might have at this point.
Thank you. Any commissioner questions for Attorney Morrow? Not seeing any. You'll have about 4¼ minutes when we come back to you. Just a minute, Ms. Yu. You're turning back to Ms. Yu. Ms. Yu, you have 4½ minutes. Okay.
Okay, thank you so much. First of all, I would like to point out from respondents' attorney's statement is exactly the same tone as the respondent indicated to me, commented to me during the phone conversation twice, Chinese lie. That's exactly he told me, and that's exactly how it reflected from Tally's statement, Ms. Morel's statement. Basically, what she stated.
Can I oh, Kelly Morrell, I'm sorry.
Yeah,
I was
yes.
gonna, thank you. My confusion, sorry about that.
I know I should have mentioned any party's name. I
Right.
heard.
Thank you very much. Thank you.
Yeah. So basically what she stated is in the respondent from respondent's response, which is absolutely manipulation of the information is untrue. The real truth is my son, the MSSM, had an on and off, so often period from in school to back home. If you look at check the background on the schedule, you will be able to find out. Towards even like early July, they have to get all of the students back home because the COVID like happened at campus. That's how my school went back home, not with our willingness, but the school let them go. And my son got infected with COVID, which we just found out the day before they returned back to school. So he stayed, I got the doctor's appointment right away, but you have to wait. We all understand the situation at the time. So hard to get to see the doctor. And the reason my son stayed is purely based on the doctors, his doctors and the heart cardiologist specialist recommendation. And play tennis, they, same as respondent and his attorney here, repeatedly misleading the tennis playing at home, which is not really the purpose at all. Even though, well, the students stay at home because for any reason, they couldn't attend the boarding school. Based on the MPA's policy and the guideline instruction, which I spoke with the executive director of MPA, understood, yes, while your child stay at a hometown, the children allowed to play, participate into the sports, because the school MSSM is less than 60 on each like gender of the students. And my son allowed to play while he stays at home, even though the doctor recommended it's very good for your son to be able to participate, good for his mental recovery from health, as well as mentally and psychological health and well-being. So we did everything based on the doctor's guidance and opinion and suggestions, which turned out for the respondent is we're lying because my son wants to stay play tennis. In fact, by the end, when the doctor understands diagnostic, he has a vasovagal symptoms, and he not allowed to play at the time, and he did not play at all. So my point is, with all these medical, needs, while we are seeking, we are also, kind of navigating the way to get the best setting and best well-being for my son, and the same ratio, the respondent, instead of helping, assisting the family and students, and he chosen to be retaliate, cohesive, and provide hostile environment, and further, even worse, resist, and said and did against myself and my son. It's a very clear stated and in writing in my complaint. And I'm very disappointed and so, disappointed and so devastating to see the report, the investigative report only took a respondent side. And I do feel again and again, the racism, the systematic racism is so rooted in
you. I'm sorry, but your time is up.
Thank you.
Okay. I'm just going to see if there's any questions from our commissioners for you. It's you. Any commissioner questions? Commissioner O'Brien?
Thank you. I could have several, but could you speak about the incident about the taking of tests and answers and all that, and could you explain how that was discrimination based on race or national origin?
Are you talking about on the analysis in the paragraph number, the first paragraph they mentioned about was the questions? Is that what you're asking me about?
Well, now I've lost it. So I'm talking about the very beginning of the analysis. And the respondent provided two screenshots of chats between the son and other students in which they discussed giving and receiving exam questions and answers, as well as behavioral incidents. How could you connect that to the discrimination?
You asked me how I'm gonna connect the respondents' comments with the discrimination. Is that your question? What I commented in my disagree response to this, I highlighted what I commented was, and this is something I've never been provided from either respondent's response or in our meetings with the respondent and his attorney and my attorney. This information was never presented prior before I see this investigator's report. And I assume this is a manipulation from the respondent because so many times we ask about any evidence. You're saying my son is bad kids. Well, he has received so many awards from MSSM, and he never said anything. We never been, myself and attorney, even never been provided anything by the respondent's response or his attorney, Ms. Morel. And this is the first time when I received the investigator's report. That was the first time I look at this fact. That's why I question about it.
Okay, and one more, looking in the same paragraph, one more, you're asserting, I believe, that the respondent had a preconception of subordinate, quiet, compliant Chinese. Do you have any basis for that? But that they had that preconceived notion?
Yes, I do, because my son stood up for himself. Actually, it comes from the beginning when I questioned about school and when I questioned about the enrollment, conditional enrollment letter. I was explained by the respondent, Sam Critchlow, saying the conditional enrollment because of the dorm key issue, the dorm key. And it nobody mentioned about the exam issue. This is the first time again. So you can see when the respondent, Sam Critchlow, respond to me, he said one thing. And when he responded to the letter, he manipulated another fact. When he told me saying, oh, the conditional letter is because the RI from the dorm told me, remand my son and did not bring the key to the dorm when he returned from home. That's why they punished him. They told him, if you don't bring back again, I'm gonna ask your parent to mail it at your own expenses. That's where it started with all these issues and the argument. And my sense,
I don't know if I explained it, and I'll try one more time. Do you have any basis? Was anything specifically said? You're asserting that the respondents had preconceived notion of Chinese being subordinate, quiet, and compliant. Is there anything specific that you heard or read to give that notion?
I heard and read was my son supposed to be just say, yes, sir. I'm going to ask my parents to mail in the key, but my son did not do that, saying, I'm not going to let my parents do that. In fact, I called them, we are traveling, we are in Florida. How could we get a key to you? And with the last minute's request, well, this thing's happening according to the RI, the communication with my son back and forth for almost a week since he returned to school. My question was, okay, so my son should say, yes, sir. And we like parents as a Chinese, we supposed just listen to you and mail in. But the fact is, if I'm home, I can do that. But I was traveling, I wasn't even home. And started right there. The RI also told Sam, and Sam said, because of that, that's the reason to give your son the conditional enrollment. Do you think that's reasonable?
Okay. I don't have any more questions.
Okay, thank you.
There are questions from other commissioners for complainants? Seeing none. Thank you, Ms. Yu. We're going to go back to Ms. Morrell. She has 4.25 minutes left.
Thank you. I just wanted to address a couple of points that were just made. First, with respect to the screenshots regarding the questions and answers to the tests, Ms. Yu alleged that she never received those. Those were provided to Ms. Yu's attorney with our final submission by email. So I have no knowledge as to whether her attorney at the time provided those to her, but those were provided to the attorney. The second thing is regarding the conditional enrollment letter that was sent to the complainant's son. That letter was based on documented behavioral issues in the dorm, and the documentation was also provided to Ms. Yu and her attorney, and those are in the record. And those conditional enrollment letters were sent to other students as well. So the complainant's son was not the only one who received one for that academic year. And that's all I have unless the commissioners have questions.
Thank you. Commissioners, any questions for Attorney Morrow?
Just to confirm what's in the report, how many other students received one of these letters, these conditional letters?
The report indicates there were 30. I think that may have come out during the Issues and Resolutions Conference.
And you feel that that's accurate?
I would think so, yes.
Thank you.
Any other commissioner questions for Attorney Morrow? Seeing none, thank you. We turn to our investigator, Angela Morse. Hi, Angela.
Hi there. I'm Angela Morse. I was the investigator for this case. I didn't find that the record supported a hostile environment claim or that the son experienced adverse treatment because of his ancestry, national origin, or race. Here, the complainant's son was granted the accommodation that he requested, which was remote learning. And lastly, there was no evidence of MHRA retaliation, and there was no materially adverse action. And I'm happy to answer any questions.
Any commissioner questions for Angela?
Yeah, I just wanted to say, based on what's transpired here so far, that I have read this investigative report very thoroughly. And I find it to be very factually based and pretty much right down the middle, and very thoroughly on. I just wanted to put that on the record. Thank you.
Thank you.
Any other commissioner questions for the investigator? Seeing none, thank you, Angela. So commissioners, you've heard from both parties and the investigator. There is one proposed finding, so we'll be looking for a motion.
Well, now we can finally.
Page 7.
Page 7. I would move there are no reasonable grounds to believe that Sam Critchlow discriminated against Christine Yu on the basis of ancestry, national origin, race, or disability, or engaged in unlawful retaliation for engaging in MHRA protected activity, and the complaint should be dismissed.
Is there a second?
Second.
So it's been moved and seconded to find no reasonable grounds to believe that unlawful discrimination or retaliation occurred. Is there any discussion among commissioners?
Yes, so I just want to say, again, this is a case, read the report carefully. I appreciate Ms. Yu's zeal on behalf of her child, and I understand that, and I understand where she's coming from. As we are all called upon to explain to folks from time to time, there are certain factual criteria that need to be met, legal criteria, in order to make out a claim for discrimination. And, you know, respectfully, those facts are just not, they're just not evident here. And so I'll be voting with the motion.
Any other discussion among commissioners? So the motion is to find no reasonable grounds on all claims presented. If you are in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
The findings are no reasonable grounds, and the commission will send parties and counsel a letter confirming that. And we appreciate your participation today. Thank you. And then we have hopefully our last case.
Our last case of the day is H230095 A and B. It's joint filed HUD number 01233468. That's James Curtis versus Dylan Andre and Trustee Wrench Property Maintenance. This is a reasonable grounds case, and as a result, we should hear from respondents and or their representatives.
Before we do that, Mr. Curtis was on, oh, he's here. Just want to make sure we get him on there too. Yep, thank you, Chelsea. So the commissioners can see him. Okay, thank you so much. Sorry, Commissioner, you were doing exactly the right thing.
I just said we'd hear from the respondents.
I believe that Attorney Bloomer,
Yes, good afternoon.
I just want to check, are you representing both respondents?
Yes, it's a sole member LLC.
Okay, thank you. You'll have 10 minutes.
Thank you. In our response to the initial complaint Mr. Curtis made, we attached Exhibit 1. If the commission has seen that. Basically, this transaction between Mr. Curtis and my clients is a text message via Facebook. There's through Facebook Marketplace. Mr. Curtis writes, "Hi Dylan, is this still available? Do you allow service dogs?" And then my client replied, "No." And then Mr. Curtis replied, "That is against the law and total discrimination. No, that's false." And in the report done by the investigator Brindley, she found there was no reasonable grounds to believe that my clients had discriminated against Mr. Curtis on the basis of disability, in part because at the time he inquired, the apartment was already rented to somebody else. But however, she did find there were reasonable grounds to believe that my clients, one of my clients or discriminated against him on the basis by making a discriminatory statement. And the word "no" is this discriminatory statement. We don't feel that is, this rises to discrimination. At the time that the request was made, my clients had no knowledge of Mr. Curtis, whether he had service animals or needed service animals. And as you find out in the report, he didn't even have a service dog. He had a pet at the time he made this inquiry. So we think that there should be no reasonable grounds to believe that Dylan Andre or Trustee Ranch Property Maintenance discriminated against Mr. Curtis. Thank you.
Admirably brief. Any questions from commissioners to respondents, counsel?
Counsel, is there any evidence in the record that the apartment was previously rented other than the statement that it was?
It's in the footnote in Investigator Brindley's report. It was rented, but we didn't submit anything in addition to that. We had our fact-finding conference with her.
So, yeah, I understand it's in the footnote. That's why I'm asking. There's no independent evidence of that.
We weren't asked to provide any. We certainly could have. We'd had to get a hold of the landlord. My client is just the agent who sets these listings up for a friend of his, and that's the agency relationship. But he's not in charge of doing the application or approval or the rental agreements. That would be the building owner who is the person that does that.
And the quotation of the exchange, "Hi Dylan, is this still available? Do you allow service dogs?" And the response, "No," you say is responding to what? The plural of dogs?
It's actually both. My client was told by the building owner that apartment, they allow one service animal, or if it was a dog, and 2 service animals if they were smaller, because of the size limitation. I guess it's a very small apartment from what I'm told.
Well, what do you say to this? It seems to me that the response "no" is responding to the last antecedent, which is service dogs. Why wouldn't he say "no, it's not available"?
Well, it wasn't available. These came up, this question came to him, he responded hours later on the timeline on his phone.
I'm sorry, what did you just?
This wasn't a simultaneous communication. There wasn't a message and then an immediate reply. There was quite a bit of time went by, is my understanding, between the time when Mr. Curtis made the inquiry on Facebook and my client actually responded to it.
So there's a delay between that, between the response "no" and the initial inquiry. Is that what you're saying?
Yes, yes.
That would strike me as even more. I would think if there's a delay, he would be being clear about what he's responding to and say, "No, the apartment's rented."
Right.
Okay.
I don't have any more information than that.
All right.
Any other, oh, sorry, Commissioner. Are you all set?
Yeah, no, I'm also.
Okay, any other commissioner questions for response council? Seeing none, you'll have about 8.5 minutes left when we come back to you.
Thank you.
Then we would turn to complainant, Mr. Curtis. You have 10 minutes.
Yes, I'd like to point out that at no time did I know that the apartment was rented until we had the meeting with the investigator, because at no time did he say, no, the apartment's not rented. He just goes on to repeatedly argue his point about why why there is no service dogs are allowed there. And when I put service dogs, I put it as plural because it didn't sound correct to say, well, do you allow service dog? So when I said that, I was asking about like service dogs in general. I had a letter from my provider and I was in the process of getting one. And during the investigation, I had provided some case law on that, and also with my disagreement, showing how this is the commission had a similar case with this. But my biggest argument is that at no time did he tell me that, no, the apartment's been rented. I mean, nowhere in the text, nowhere in anything. And then all of a sudden, it's like him saying that he knows the law, that he doesn't have to allow service dogs. And that's what the whole conversation was about. And if you look at the timeline, I don't know if there was a major time difference between when he says no and then him arguing his point about why he doesn't have to allow a service dog. And that's basically my argument.
Thank you. Also admirably brief. Any commissioner questions for Mr. Curtis? Seeing none at the moment. We would turn back to Attorney Bloomer. Attorney Bloomer, you have 8.5 left.
I don't think we need, we made our point, our position. Thank you for the opportunity.
Any commissioner questions for respondents council? Going once, going twice, none, thank you. Mr. Curtis, 8.5 minutes.
I just feel that from the beginning, once the service animal was brought up, he was not going to rent to me no matter what because of the service animal. So without me knowing that the apartment had been taken, I don't see how it wasn't like he was refusing to rent to me, because it's based on once we, like I said, if the text message is clear, at no time did he say, no, this apartment's been rented. At no time did I even know that until we had the thing with the investigator. And then that's when he explained stuff in that the apartment had been rented, but at no time has it ever been proven that the apartment was rented. And, you know, and as far as he said that all applications had to be submitted to him and then he submitted them to the landlord. Well, at no time, the whole time while I was talking to him, I thought that he was the landlord or at least the property, you know, company or something because of what the title was. So I didn't know that the apartment had ever been rented. So until, like I said, that's what my argument is I feel that he did discriminate against me, not rent to me, because of the service dog issue and his adamant argument of why he didn't have to allow it. And that, you know, he kept stating that he knew the law, he'd gone over it with attorneys. But again, it never goes back to anything that shows that the apartment was taken or that he even informed me that the apartment was taken. So that's my argument.
Thank you. Any commissioner questions for Mr. Curtis? Being none. Thank you. We would turn to the investigator, Alex.
Good afternoon, everyone. So I do want to discuss what was just brought up. So there was the comment about how I had not requested evidence that the apartment was rented. And thinking back, I know I had a reason for it, and I think likely it was due to the fact that during the Issues and Resolutions Conference, I had no indication that Mr. Andre was lying about the fact that the apartment was in fact rented, and also Mr. Andre is not the owner of the premises, but perhaps I should have requested proof showing that the apartment had in fact been rented or was in the process of being rented at that time. So maybe my analysis would change depending on that document. But other than that, I think the discriminatory comment claim is pretty clear. I mean, in the text that's provided in the report, you see him say no, a blanket no to, is this available and do you allow service dogs? And then they continue to talk about Maine law in regards to service dogs. And further on in the investigation, Mr. Andre also stated that multiple service dogs were not available on the premises, which itself is also a discriminatory comment, because a landlord or property manager or any housing provider cannot limit the amount of service or assistance animals that a tenant can have. It all depends on the doctor's note. If you have multiple assistance animals prescribed to you, you can have multiple assistance animals in your property. But I think that's the entirety of my summation. So if you have any questions, I am here to answer them.
First Commissioner David, then Commissioner Brown.
Alex, thank you again for the edification about service animals and assistance animals. You know, sometime in the next 4 years, if I'm still on after the first 4 years, I'll get it right. But I'm beginning to understand. And I certainly tend to agree that with the second conclusion that there's a discriminatory statement there. But as you say, the key might be whether or not the apartment was rented. And I'm struggling with whether or not he's saying here in this presentation that he was never told that it was rented. And I just can't believe that wouldn't be the first thing that the landlord would respond before getting down into the weeds about service animals, assistance animals, plural, singular, whatever. But the point is that it is the case that there is nothing in there except his statement that it was not available because it was rented. There's no documentation of that.
Correct. There is no message exchange between the respondent and the complainant stating that the property is unavailable, but also at the same time, it doesn't say that he's not allowed to apply. It was mostly just the conversation about the assistance animals.
Right. Thank you.
Mm-hmm.
I have a question for Alex.
Yes, Barbara.
Did I hear you say that if there is that asking for the proof about whether it was rented could change your recommendation?
It might. I probably would say no, because the respondents in their answer and then later on in the IRC stated that it wasn't available, and I got no indication that they were lying about the fact that it was unavailable. They stated that there was a lot of interest in the unit, which, you know, given the current housing market, makes sense to me, but I guess I don't know the answer to that question because I don't have the document.
Okay, fair enough. Sorry.
Commissioner Bryan, do you have a question?
Yeah, I think so. Is it clear to you or not that the issue of the unavailability of the unit was not discussed, brought up until the conference? The issues and resolutions come to me that kind of is important.
So you're asking if the issue in regards to not allowing him to rent was when he was provided notice?
No. Mr. Curtis, I believe, suggested or proffered that he did not even know anything about it not being available until the Issues and Resolutions Conference. Is that what you believe?
So there is mention that the unit was unavailable in the respondent's initial response to the complaint. But yes, in their initial conversation, the complainant and the respondent, there was no comment other than the first initial blanket no. There is no discussion into whether or not it's available.
Thanks.
I'm gonna keep us down this rabbit hole for a bit.
Thank you.
Only if that sounded insulting, and I don't mean it to be. That's the rabbit hole I want to be in.
No.
Only if it's in the record, of course. Did this property manager manage other properties for the same landlord at the same time?
From what I understand, it wasn't so much that Mr. Andre was the property manager for the owner of the premises. It was more he was contracted to do specific things. So in this instance, he was contracted to post the Facebook message, or like the Facebook post showing that it was
For this unit?
Yeah, for this unit. Although I could be wrong. It's been at least a month and a half since I wrote the report. If the respondent has any contradicting information regarding that.
Well, I see the complainant asked, is this still available? So he's referring to that unit, and that's fine. Maybe that's the end of the analysis. But you know, if you go to a property manager who has 100 units and you say, do you allow service dogs? And they say no, I think you have a pretty good argument that they're denying you the housing at that point. And so if it's this particular unit and we're getting all hung up on whether this particular unit was available or not, is there a distinction between that situation and the one I just gave? I mean, do you allow service dogs means I am never going to, and the answer is no, I'm never going to rent to you if you have a service dog, period. And isn't that a denial of housing?
Well, I think there, you don't really get past the initial question of whether or not you allow service animals. Certainly a complainant can make an inference that if they don't allow assistance animals, assistance animals, that the property wasn't available to them. But there really is no discussion on whether or not the property is available or whether or not they decided to rent to another person because of complainant's request or question about assistance animals.
I think you're right. I mean, I think the record can't let us make that assumption, but my instinct tells me that if the answer is no, that doesn't matter whether it was vacant or not, or whether he was a manager of 100 units or one, this person was not going to be able to rent at all, and that's a denial of housing. But I don't think the record factually supports that. I think we have to take the respondent's reply as the only fact in the case on that issue, and that is the only factual assertion on that issue in this case, and that is that the apartment wasn't available at the time of the inquiry.
I think I would agree.
Any other commissioner questions for the investigator? Seeing none. Thank you, Alex.
Thank you.
So commissioners, you've heard from the parties and the investigator. There are two proposed findings. Yes.
I'll recommend that we take them together, that we adopt the findings of the investigator. There are no reasonable grounds to believe that the respondent discriminated against the claimant on the basis of disability by refusing to rent or making housing unavailable. And that claim should be dismissed, but that there are reasonable grounds to believe.
I'd like to take it separately.
Oh, okay, I'll stop there. I'll stop then. Full stop, no reasonable grounds.
Could you clarify your motion for me, Commissioner?
Yes, I'll amend a friendly amendment. We don't take the investigator's reports. If I can, I'll have to amend my own motion. That we don't take the investigators' reports together, findings together, but that we take first, that there are no reasonable grounds that the respondents discriminated against the complainant on the basis of disability by refusing to rent or make housing unavailable, and that this claim should be dismissed in accordance with the Act.
Is there a second? Second, Commissioner O'Brien. It's been moved and seconded to find there are no reasonable grounds on making housing unavailable or refusal to rent. Is there any discussion among commissioners? Yes.
Yeah, I think you're right, Commissioner Ashby, that the issue is whether or not the apartment was available at the time of inquiry. And at the time of inquiry, he says, is this still available? Do you allow service dogs? To which the response, somewhat delayed, I now learn, is no. It would see it, I just can't get beyond my own reaction that if the apartment was not available, the response would have been, no, it's rented, sorry, have a nice day. And it's not. It's responding to service animals and getting into that discussion. And I think I understand that my initial reaction is not what's critical, but it's what leads me to say that there's at least an even chance that he would prevail in a civil action on that issue of if it comes down to credibility. If there is no evidence, if there's evidence, then there's evidence, but it's not here. I think that he's responding that no, I'm not renting to anybody with service dogs. So I'm going to vote against the motion, and if it's defeated, I'm going to make a motion that there are reasonable things. So we'll see.
Any other discussion among commissioners? Seeing none, looks like everybody's thinking. All right, John.
I am, I'm thinking.
Just give you guys a minute.
I think we're stuck with the record on that question, and I don't think. Well, you could tell from my questioning, and you can tell from that I'm sympathetic to your position, Commissioner David. I'm going to vote for my own motion because I think the record that developed is that apartment was unavailable at the time of the inquiry, and we don't have any record that this person had other apartments to rent, or that other apartments were inquired about. I can make some assumptions about what the landlord would do, but I don't think that rises to even chance.
Any additional discussion among commissioners? Seeing none. The motion is to find no reasonable grounds to believe that respondents discriminated against complainant on the basis of disability, refusal to rent, or making housing unavailable. If you're in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
No.
Commissioner O'Brien?
No.
Commissioner Douglas?
Yes.
I'm sorry.
Second.
No, I did.
So the vote is tied, and under the commission's procedure.
Well, they can make another motion first. That's it. We'll see if that one's a tie too. Okay.
Does it matter?
It does.
It may.
It might.
It could.
Let's say this in a different ways.
I move that the commission find that there are reasonable grounds to believe that respondents discriminated against the complainant on the basis of disability by making housing unavailable, and that the complaint should be referred to conciliation.
Is there a second?
Oh, no, I'm so. We'll second anything, right? Yeah.
There's the motion is to find reasonable grounds on the first claim, disability discrimination, refusal to rent, and making housing unavailable. It's been seconded. Is there any discussion on commission? Seeing none. If you're in agreement with the reasonable grounds finding on making housing unavailable or refusal to rent, you will vote yes. Commissioner Ashby?
No.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
No.
So
now we have the
rules. So the procedural rule provides that in the event of a tie vote, the default is the recommendation is to adopt the investigator's recommended decision, which in this case is no reasonable grounds.
Why wasn't the first vote?
Because that's what I was about to do when she stopped me.
If your motion had actually changed someone's mind and it could have been.
Oh, I see.
tied.
Okay. But it is the case that since they both come out as a tie, that
Yes.
it's the default, yeah.
Yes.
All right, yeah, I got it.
I'll try again. Move that there are reasonable grounds to believe that the respondents discriminated against the complainant on the basis of disability discriminatory statements. And conciliation.
Yes.
Conciliation of this kind should be done.
Is there a second?
Second.
So it's moved and seconded to find reasonable grounds to believe that there were discriminatory statements. Any discussion?
Yeah, I mean, I've been silent up till now. I'm having a really hard time with this record here, and after what everybody else is having a problem with, this initial exchange. Is this still available? Do you allow service dogs? And responded after a delay, as Commissioner Davis points out, says no. No, which is he responding to? We don't really know, but then we learned that, he says later, he told the complainant, no, because the place is no longer available because the unit only allows one service dog or two service cats, not multiple service dogs. And I just feel like on the basis of this brief exchange, I think it's close, but I don't see how we can find reasonable grounds to believe that these discriminatory statements occurred, so. That's where I'm at now. Ask me again in 5 minutes.
So, if I may, I mean, I think that what I found significant in that exchange is that the complainant immediately turns to a discussion about service animals. And the respondent doesn't say, no, I want to make sure you understand what I'm saying. It's that the place isn't available. Instead, the respondent gets into an argument with him about what needs to be supplied in terms of service animals. And I think the respondent is wrong in his reply. And I also am, like the investigator, I think that it's unlikely that the respondent answered no when the question was, do you allow service dogs? I think it's unlikely that he said no because dogs was plural. That's the complainant's right. You don't say, do you have service dog? Do you allow service dog? They say dogs. And the answer was no, I don't let, if there was a concern about how many, the first question would have been how many dogs do you have? And that didn't happen. So I think it's a credibility problem here. I think, but even that, I think that the understanding by the respondent that you can't have more than one service animal is also wrong. And I think he did answer no to do you allow service dogs? And those are all violations of the act.
Other discussion among commissioners? Seeing none. So the motion is to find reasonable grounds based on discriminatory statements. If you are in agreement, you will yes. Commissioner Ashby?
Yes.
Commissioner Davis?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
No.
The finding is reasonable grounds regarding the discriminatory statements. So there's no reasonable grounds and one reasonable grounds. The commission will provide a letter to the parties confirming that. And we appreciate the parties' participation in today's hearing. And that is the end of our hearing agenda. And at this time, we will be looking for a motion that cites the FOIA statute to go into executive session.
Pursuant to 1 MHRC section 405-6E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Is there a second?
Second.
The moved and seconded to go into executive session, citing the proper sections of the statute. Is there any discussion? Seeing none, if you're in agreement, we'll vote yes. Commissioner Ashby?
Yes.
Commissioner Davis?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Okay, so we will be going to executive session for folks who are still on the call and don't work for us, which is almost no one, except for Mr. Burns, I believe. We will be going off camera and off mic for executive session. We will return to open session when we are done with executive session. And yeah, that's it. So Oh, yeah, I don't know. It's supposed to. Oh, sorry. Good, that means we're back on YouTube. Oh,
There we go.
thing happened.
Maybe.
Thing happened.
Yeah.
You really don't want me doing this.
Yes.
There you go.
Good.
Wait, we're missing one. What am I doing? Head, there it is.
There you go.
That's
I would
what
move that we not litigate the case of MHRC case number E 220168.
We'll fill in the name.
Beyond Kamano.
Yep.
First single family dwelling.
There a second.
Second.
So it's been moved and seconded to not litigate E 220168. Is there any discussion? Seeing none, if you were in agreement with not litigating that case, we'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Bryan? Yes. Commissioner Douglas?
Yes.
That's a wrap.
Move to adjourn.
Move to adjourn.
You don't even need a motion. We could, yeah, we could, but I heard everyone make that motion.
Yeah.